Another for these orders also.
All right.
May I-
For withdrawal, one I for withdrawal.
May I please, your lordship?
Yes, yes.
Your lordship, I beg to listing of an MSc appeal, your lordship, for orders on 16/9, your lordship, next Tuesday.
69, yes.
Highly obliged.
May it please your lordship, I pray for listing on RFA method on Wednesday for orders.
Wednesday, fine. Yes.
May I please, Lordship?
Mm.
I beg to mention for listing of an 3 item, Lordship. One is two is RFA and one RSA item. In this week, another date may be fixed. Any other?
This week another date.
No. It's not. For listing. 11 September.
This week, no? Yes.
My lord, I beg to mention for listing a MSc appeal, my lord, on 10th, my lord.
10th, fine, 10th.
Orders.
Orders column 1.
May I please, my lordship? My item number is 29.
Hmm.
The counsel for the railway responded, Mrs. Uma Chakraborty has some medical emergency.
Okay.
So adjournment may be granted
Okay.
after puja vacation. After
29.
puja vacation,
I think your, which item? Item number?
29.
29.
No, 28 is different. Uma Chakraborty's name is not in the item number 28.
But the matter is tagged.
Then,
My lord, I am appearing for the petitioner in this matter.
but she has some medical emergency. She cannot come today. She's in the hospital.
Fresh matter, lordship may consider notice issue at this stage, my lord. The fresh matter.
No. She is not well.
Then any date may be fixed, my lord.
Yes, of course. Learned Counsel, Miss,
Pardon?
what is your name?
Dipali Kolita.
Miss D. Kolita, on behalf of Learned Counsel, Miss, Learned Standing Counsel for NF Railway, Miss U. Chakraborty has paid for adjournment as Miss U. Chakraborty is not well. Full stop. List the matter on.
11 September. 11 September.
She's not well
No,
Any
she
date, ma'am. Any
wanted
date.
after puja vacation.
after puja vacation.
My lord, if any date.
Date will fix be. List the matter on 15th October.
Obliged.
My lord, may I please, your lordship?
28.
Yes,
Yes.
deeply obliged.
My lord, one pending matter, MSc appeal, my lord. It was last listed 28/3/2024, my lord. So matter may come on, my lord, 16, my lord. 16. Or
Yes.
May I please, your lordship? I beg to mention item number 19, lordship, and adjournment matter for today, lordship. Item number 19,
Adjournment.
adjournment.
Learned Counsel, Mr.
GG Gogoi.
Huh?
GG Gogoi.
GC Gogor has prayed for adjournment. List the matter after vacation.
Before vacation, your honor. Before vacation.
Before vacation, not before vacation, after vacation. This is at which stage? Admission?
Admission, lordship. For hearing.
No, not before vacation. No. If you can, then you submit today or we'll list it after puja vacation.
May I please, lordship? I beg to mention for
List
listing
the
of
matter
this
after puja vacation.
CRP, lordship.
Yeah.
And also 2016 matters. Maybe listed on 15.
Yes.
May it please, your lordship. I beg to mention listing of 2 MFS, my lord. Any date, if any date was much obliged.
May I please, your Lordship? I beg to mention for listing of a IA for order column on next week, Lordship. And another item for RSA that is also for orders column. Masu.
May I please, your lordship? I beg to mention for listing 2 RSA matter, lordship, 11 September, lordship.
Not on 11th September, 17th September.
Deeply obliged.
May I please, your Lordship?
I would like to mention item number 3 with the consent of other side.
Item number 3,
Yes, your lordship, for adjournment.
Learned Counsel, Mr.
A.R. Shom.
A.R. Som,
I have taken consent, lordship.
with the consent of the other side has prayed for adjournment.
I'm there, my lord.
Okay.
Next week, any date, your lordship, except 19.
Next week, any date? List the matter on 17th September.
Meanwhile, my lord, some defective is there, my lord.
I'll supply.
Annexures.
I'll supply.
17 of Bishakarma Puja.
Bishakarma Puja, yes. But we'll be working
15,
after puja.
15, 16, 15, 16. 16. Obliged.
16.
May I please, your Lordship? Lordship, I beg to mention MSC 416, listing on 16 September. 16.
May it please your lordship, I beg to mention one regular second
Second
appeal in this case. Appeal was admitted and the stay petition notice was issued, lordship. For orders column day after tomorrow, lordship, they have
Day after tomorrow,
filed
filing orders
execution
column.
petition.
On 11th? On 11th.
11th, lordship, and one another order matters RSA early hearing we have filed and we have taken step for service report on 11th, lordship. Both are order matters, lordship.
Orders on orders.
Yes, sir.
Filing 11th.
Any motion
File
day
no-
or
Yes, yes. All right.
lordship? Obliged, lordship.
May I please, your lordship.
Hmm.
Lordship, I beg to mention item number 1, my lord. My
Hmm.
lord, report was called for, my lord, report has not come.
Record, trial to record as called for is not received. Issue reminder list.
Report was called for, lordship.
Huh?
Report, my lord.
Oh, report, okay.
AB, my lord.
Okay.
Whether any
Report
FIR
as,
is also not.
report, I heard record. Actually, I don't know, whichever court I go, I don't know, the speaker seems to be very low.
Yes, Lordship.
Whichever court, in 21
Am I
also,
audible, Lordship?
18 also, it was not like that.
Am I audible, Lordship?
Of course.
Yes. Lordship, here report was called for regarding filing of FIR, Lordship,
Hmm.
in respect to the petitioner. That report we have not received. That's why I'm waiting for some more time.
Report as called for is not received. Issue reminder list the matter, huh?
Yes, Lordship. Can it be on 24th?
24th, yes.
Yes.
24th, yes.
Yes.
Finally, on 24th. Because you see, last week we will be having only motion week. That is why
Yeah,
I'm
yeah,
asking.
that's what, that's what.
May I please, your lordship? Lordship, I beg to mention item number 44.
Hmm.
Well, 44 is a fresh matter. It's a civil litigation petition against the order of the family court.
Hmm.
However, what has happened that on 6th of September, there was some fresh development in the case and which may affect the hearing of the case. Therefore, my lords, we seek liberty of this court to withdraw the matter to file afresh again.
File what?
Afresh. To withdraw this matter and liberty to file again, my lords.
You can take the liberty, but there's other, we have the other party also involved.
My lords, this is a fresh motion
Fresh
matter.
matter, okay, okay. Some 44 too.
Right, please, Lordship.
Just a moment.
I am paying for listing of I number 3293/23.
Hmm.
It was last listed on
It's- I just
15/3/2024.
ahead of- ahead of it.
Fresh matter has come for the court for the first time, my lords.
You'll be withdrawing this entire matter along with the IA.
Yeah, yes, my lords. And we'll file it fresh because, my lord, there is a date of.
This is not registered, you cannot withdraw. You can withdraw only the IA.
Yes, my lords.
Uh,
Once the.
Main case is not registered.
Okay, my lords. So both may be.
No, no,
Okay,
no, it is not registered.
okay,
We have only the filing number.
my lords.
Learned Counsel Mr. M. Manas Burman.
Yes, my lord.
M. Burman has paid for withdrawal of the interlocutory application. With a liberty to file a fresh. With a liberty to file a fresh revision petition. Petition is dismissed on withdrawal with a liberty to file a fresh liquid, AFRE.
I'm so obliged.
May I please, Lordship?
Hmm.
One matter appeal, Lordship. There is a possibility of settlement, Lordship. I am praying for listing in
Which
immediate
one?
Met appeal
Okay.
for listing on Lordship 11th, Lordship. There is a
11th.
possibility of mediation.
Yes, it's okay. Fine, 11th. Not a belegata date DD. 15 September.
15.
May please, and also one MSc appeal, Lord,
Hmm.
2018 matter, Lord.
Hmm.
I'm praying for a date to be fixed for hearing, Lord. Already in the matter, for the hearing column, Lordship. But it has not been listed since last.
Not listed. Okay,
Any day,
after puja vacation.
Lordship. Obliged.
You want to say something?
It's coming up at number 7.
Okay.
Yeah, please, your lordship.
Hmm.
Lordship, it's a very limited prayer on the part of the petitioner, lordship. He filed an application before the learned family court, lordship, for adducing further evidence, and that was rejected by the learned trial court only on the ground in the list of witness, the names are not there. So this is the basic reason for which my application for adducing evidence that has been rejected, lordship. Further evidence on behalf of other witness, lordship. Two evidences
You want an
were,
order at the motion stage?
lordship.
You want an order at the motion stage? Not possible because their names are not there. So we'll issue notice.
Stay may be required, lordship. Stay of the person.
Yes. In which paragraph you have given the ground?
Lordship, in page number 9, the ground number D is there. Ground number D. Although the learned trial court did not take note of the fact that reducing further evidence that the petitioner was not going to cause any prejudice to the petitioner, as the respondent would get sufficient opportunity to cross-examine those witnesses, and as such, by rejecting the prayer of the petitioner, the learned trial court overturned the arbitrariness.
Their names were not in the list.
Yes, Lordship, that is the only ground, Lordship.
So in this case is pending at which stage?
Evidence stage, Lordship. Now the evidence of the DW will come, Lordship.
Evidence, defendant's evidence.
Yes,
Okay,
Lordship.
all right. Where is the impugned order?
It is, Lordship, at the last annexure. Start from, Lordship, page number 22. The operative portion is at page number 23, Lordship.
I'll just read the order,
Yes, Lord.
or else you can read the order. Entire order.
Lordship.
I'll read or you will read.
The
order.
last paragraph, Lordship, page number.
No, no, not
Yes.
last paragraph, entire order,
Yes.
starting from the third paragraph.
This order arises.
No,
Petitioner
no,
is at
paragraph,
page number 22, Lordship.
page number 22.
22. Petitioner is absent but is engaged amicus is present by filing Hajira. Respondent is present with his engaged amicus. This order arises out of hearing both the sides on petition number such and such filed by the petitioner under section 150 CPC, praying for allowing him to reduce further evidence and written objection thereto filed by the respondent by petition number such and such. By filing the petition number 1094, it is contended by the petitioner that due to negligence of his earlier engaged amicus, the evidence stage of the petitioner side was closed to, though he has more witness to examine, for which there is every chance that his case may fail, and as such he paid for allowing him to examine both more witness by posting the case for further evidence of the petitioner side. On the other hand, challenging the petition of the petitioner, the respondent filed written objection contending entirely that there is no cause of action for filing the petition, that the petition is not maintainable under section 150 and CPC, that there is no list of witness filed with the petitioner under order 16 CTC to show that he has more witness to examine, that when the respondent has already filed her examination in chief and case is posted for cross-examination of the DW, it will cause prejudice and irreparable loss to the respondent in her defense if the case is reviewing back to the stage of further evidence of the petitioner's side. That the evidence of the petitioner's side was closed after hearing the petitioner and his engaged amicus. As such, there is no scope to reviewing back to the stage of further evidence of the petitioner's side. Hence, the contesting respondent prayed for rejecting the prayer of the petitioner. I have heard the learned amicus of both the sides on the petition under consideration and also gone through the case record, including the order sheet. It transfers from the case record that the petitioner instituted the instant suit against the respondent under section 13(1) of the Hindu Marriage Act, praying for passing a decree for dissolution of his marital tie with the respondent on the ground of cruelty. It transfers from record that the petitioner has not filed in record the name of his witness, rather submitted the examination in chief of PW 1 and 2, that is the petitioner and his mother. It transfers from the order dated 18/12/2024, the cross-examination of the PW 2 was over on that day, and the petitioner side expressly declined to adduce further evidence, for which the next date was fixed on 5/3/2025 for defense evidence. Two DWs filed their examination chief on 6/5/2025, and on that day itself, the petitioner filed the petition under consideration, praying for allowing him. Lordship.
Paragraph? Ground B, no?
Ground B, Lordship.
Our learned counsel, Mr. SP Sodhi. SP
Yes,
Sodhi,
yes.
for the petitioner. Naam na lage, huh? Dinesh Kesar, who has filed this application under Article 227 of the Constitution of India with prayer for setting aside the order dated 5/7/2025 passed by the learned principal judge family court Kachar and Silchar rejecting the petition of the petitioner to adduce further evidence in connection with FC civil case number 74/2023. First of, it is contended that the order was mechanically passed without assigning any without assigning any valid reasons. Full stop. It is contended that the petitioner's case would suffer if the petitioner is not allowed to adduce evidence. Full stop. I have scrutinized the impugned order. It is some wherein it has been observed that even the list of witnesses which the petitioner is willing to examine was not furnished. First of earlier, when the evidence was submitted, earlier when the written statement or
Evidence, Lordship.
earlier when the evidence was submitted, the petitioner did not mention the names of the any other witnesses in the witness list apart from the names of the petitioner. No, you have not mentioned any name.
Exactly, Lordship. No, that
Has
that
not
aspect was
submitted
not
any.
there, Lordship. That application was never filed, Lordship, with regard to the
No.
yes,
No.
denial to adduce
When
further
you
evidence.
submitted your plaint, you are the plaintiff.
I am the plaintiff, Lordship.
When
After
you have
submitting my evidence, Lordship.
When you have submitted your evidence.
Yes, Lordship.
Then you have not submitted any list of witnesses.
Yes, Lordship. That is the point taken by the
No,
Lordship.
has not submitted.
Otherwise, as per
with-
provision of
apart
order
from-
16 rule 1A, Lordship,
Has
it is
not
not
submitted
mandatory.
any list of witnesses while submitting the plaint. It is, I have considered the submission of the petitioner that the evidence, the case is pending at the stage of defense, evidence of defense witnesses. Thereby, further proceeding of FC civil case number 74/2023
Yes, Lordship.
is hereby stayed till the next date of listing. Meanwhile, issue notice to the respondents returnable within 4 weeks. List accordingly.
Yes, Lordship. Obliged, Lordship.
Item 4.
So in this case, my learned friend submitted caveat, but unfortunately that was copy was not served. I shall serve the copy. It may come day after tomorrow. Also.
Day after tomorrow, fine. No, not day after tomorrow.
Then on Friday.
No. 15 September.
15 seconds.
As agreed by both the parties, leave the matter on 15 September is Friday. Monday,
Item 5.
September.
Obliged.
May I please?
Hmm.
My lord, in this case, my lord, what happened? The PW petitioner before lordship is the plaintiff, my lord. One of his witness, my lord, that is PW2, my lord, on the date fixed for his cross-examination, he failed to appear due to his sickness, my lord. But that petition was rejected and his evidence was expunged. And my lord, the evidence of the plaintiff is closed and now the case is fixed for defendant evidence on 22/9, my lord. Lordship may kindly come to page 37, my lord. That is the petition filed for seeking adjournment, my lord. Page 37, my lord.
Page 37, yes.
Yes, my lord. This is the petition,
Where is
my
the
lord.
order?
My lord, order is at page, my lord, 38, my lord.
Page 38, okay.
Yes, ma'am. But I pray for only one opportunity to the PW2 to face the cross-examination, my lord, because he is one of the vital witness to prove the, my lord, agreement, my lord. Only one date he may be allowed, my lord.
How many years you have taken earlier?
My lord, earlier, my lord, what happened, there is one application filed that since he is aged about 78 years and suffering from various ailments, to allow him to be cross-examined on commission, my lord. That petition was rejected, my lord. I have annexed that order. So at that time, my lord, one adjournment was sought, earlier sought, my lord. That order is lordship may find page number, my lord, 36, my lord.
No, 78, 58 years. He's 58 years.
My lord, 78, my lord. In the petition, my lord, I have annexed, my lord. Well, PW2 is 78 days. ma'am. PW2, I have annexed the petition for commission, my lord, page 29, my lord.
Okay, then only one opportunity.
Only one
I'll
opportunity.
dispose it of.
Yes, ma'am.
You give cost also.
Yes.
Third learned counsel, Mr. A.K. Gupta for the petitioner. Family court case.
No, my lord, this is
Title suit.
title suit, my lord.
For the petitioner, Sri Sudhir Kumar Chaudhary, who has filed his application under Article 227 of the Constitution of India to, with prayer for setting aside the orders dated 16/6/2025 and 17/7/2025 passed by the learned civil judge senior division Tinsukia in title suit number 62/2017. Full stop. It is submitted that the cross-examination of the PW2 was rejected. Full stop. A petition, more particularly, annexure
Page 37, my lord.
F, annexure F of this petition was filed on behalf of PW2, who was not well, who submitted the PW2 is 78 years old, full stop. It was observed by the trial court by order dated 17/7/2025 that several adjournments have been granted for examination of PW2, but in reality, this is not so. To stop, it is submitted that earlier, as PW2 is 78 years old, there was a prayer for cross-examination of PW2 through the commissioner, which was rejected. Annexure, which one?
Annexure E, page 36, my lord.
Annexure E is the order dated 16/6/2025 rejecting the prayer to cross-examine PW2 by appointing a commissioner. Full stop. I have considered the submission that the petitioner has prayed only for one last opportunity to produce PW2, who is 78 years old, as a witness before the court to be cross-examined. Full stop. Thereby, the order dated 17/7/2025 is set aside. And we'll have to set aside this order. Although there is no error in this order, I'll set it aside because his evidence has been expunged. Is set aside as the full stop. The petitioner is directed to produce PW2 on the next date fixed by the court to be cross-examined by the court. In terms, only one opportunity is accorded to the petitioner to produce the PW2 to be before the court to be cross-examined. In terms of the above observation, this petition stands disposed of.
In this case, we have carried the order dated lordship 25/9/2024 lordship, arising out of a petition under section 5 of the Limitation Act in a claim petition filed by the petitioner.
Issue notice, issue notice.
There in this case, there is a covered order in this.
No,
case,
no,
lordship.
issue notice.
There is a order, lordship.
No, covered order. There,
Clearly
mistake emerges if we take a resort to covered order. Issue notice. Because we do not know the original of the case. Let me see, covered order.
Similarly situated person has approached this honorable court, similar matter, and this honorable court disposed
No,
of.
I will grant you issue notice. This was rejected limitation. How many days limitation?
It's 95 days only.
Because it's a claim petition, Lordship, it had been prevented by sufficient force in not filing the petition in time.
Claim petition.
Yes, claim petition in a accident case, Lordship. Start from, kindly peruse the paragraph 6 of the order. Similar case. Here in this case, Lordship, the what 166(3) of the MB Act provides that 6 months time is there. Within that period, the petitioner ought to have filed petition, Lordship. But the Honorable Supreme Court has held that the 6 months time will not be reckoned when an affair was lost, Lordship. And that
What?
when any affair was lost, Lordship, in the after occurrence of the accident, that 6 months time for filing claim petition will not arise, Lordship, under section 166(3). And therefore, here in this case, the petitioner has lost the affair immediately after
Will it the old MB Act or the new one?
new 166(3). All
New
MB
MB Act?
yes, there was no limitation in the
After 2021.
after 2000, there is a amendment, Lordship, for filing the claim petition within 6
Notun
166(3).
How old is this case?
It's 95 days delay, Lordship. Is 2024, they have filed the claim petition, Lordship. Incident occurred on 10/5/2023. They filed the petition on 16/2/2024.
166(3).
166(3).
So this is not required in case where
Affair was lost.
FIR has been filed. Where it has been held?
Paragraph 6, kindly.
Paragraph 6.
6 of the order which I have submitted before you. This honorable court had discussed the two decision of the honorable
Let me
appeals
see.
court.
Very acid. No, online. Ombra খানি ফেনখন 1 নম্বৰ দি দিব পাৰিম। You have the Supreme Court's judgment?
Lordship, I could not collect in a hurry, Lordship.
Tomorrow then? Day after tomorrow?
Okay.
কেতিয়া দিলে ভাল হ'ব? Huh? 11? Not very far away.
I'll bring that.
Yes, you
On
bring
that
the
day.
judgment.
Yes.
Yes. Then I think I may pass an order after going through the judgment.
Yes, yes, yes.
list this matter on 11 September. Yes.
My lord, I'm Sanchita Roy Choudhury, the petitioner in person.
Mm.
And the impugned order is PTS 11/24. And the date of the order is 31/7/2025.
Mm.
Actually, this is a probate case of my father, and we are 2 daughters and only children. So the testator, my father, so like he had granted his grandchildren respective children of the 2 daughters vested rights with the mothers, respective mothers. Now I'm the younger and executor, so I placed it for probate after mom expired. And the condition is that this should be placed for probate only after both dad and mom have expired. So after that, this has been contested. So the contest issues have, they've brought in many issues. And the order, my lord, the order is in page, the impugned order is in page 199 to 200. In page 200, it states that there are 3 issues have been framed.
Okay.
It's whether the instant probate title suit is barred by limitation, whether it was duly executed and attested in accordance with law, and whether the testator had sound disposing mind. But ma'am, I mean, my lord, if you could please go to page 197. That is the previous order of 16/6/25. So here it is clearly stated that I had actually, in answer to their all the issues which they had placed in their written statements, actually respondent 1 is my sibling, and 2 to 4 are her children. So they filed separately, but more or less ditto in matter, and just with few changes in wording. So against those issues which they had raised, I had placed my rebuttal. And that has been stated as 972, petition 972/24. So despite all the issues which I had rebutted, those issues have not been taken into account. And among the issues, I'm stating it frankly, they have raised the legitimacy issue of mine with reference to my father. And I'm a divorcee, and my son, an only child, he has expired. So they have clearly stated that he's not my ex-husband's child, and I have to prove. My son expired in 17, and I have to prove with admissible evidence. So that is there, because my son has a vested right in the Guwahati property. But they have also admitted that my son, Shamek Pudar, is my ex-husband's and my son, and that we, the 2 daughters, that is Mrs. Tapushi Shah and me, Sanchita Roy Choudhury, because I'm a divorcee, so I've reverted back to my maiden surname. So they have stated that we are 2 daughters of our parents, late Amalkanti Roy Choudhury and late Shilata Roy Choudhury. So that's one issue which I want to have taken it up, because in a probate case, if the legitimacy issue of an heir is brought up by direct or implied, because they've stated law will decide on the legal class 1 heir of the father. So that issue has to come up, because ma'am, if, my lord, if like it's taken that way that I'm not my father's daughter, then I shouldn't be in this probate case. And secondly is they've also referred to joinder of properties without naming. Now, as per a ruling of the Honorable Supreme Court.
We don't have to go that far. You want some additional?
So
issues
I
to be
want,
framed?
yes, ma'am. I just want, 1410 is the next date. So I just want,
This case is pending at which stage?
it's an additional number 1, district
No,
and section
no.
third, Kamrup Metro.
Stay pending at the stage of evidence.
It's just, yes, ma'am. It's on that, in that page 200, it's 199. The next date is given for evidence of the plaintiff. So, ma'am, just if my humble submission is that the learned trial court take up all the issues, given that they have already referred to me having submitted my rebuttal.
See, it's not very easy. We'll have to delve into, we'll have to
Go into.
Yes, go deep into the case. So now at this moment, we can stay the order and we can issue notice.
Yes.
Because you are the plaintiff.
I'm the plaintiff.
Okay.
Because without a joinder issue being settled, the order will be invalid. Then again, they have stated that the testator suffered from senile dementia. So I had already admitted he suffered from senile, it was diagnosed in 2006, but the will was made in 2003. And at that time, just 3 weeks prior to the will, making of the will, the testator was a petitioner in person in the Guwahati High Court. So that order is also given. And they have denied those two orders.
It's not required. I am willing to stay as this. We'll
So
stay till the next date and then we will issue notice. Let them come.
Okay.
We'll hear both the
Both the
parties.
parties,
Yes,
yes.
and then because now it's you are the plaintiff in a
I'm the
original
plaintiff.
suit. So we'll stay.
Because, my lord, I had also put up the thing that because they have denied the legitimacy and they have admitted in clear terms, so it comes into the false affidavit, which also.
We'll get into those details. Oh, my.
And my lord, that's why my mention of Article 21, that is right to life and right to reputation as per the Subramaniam Swamy versus Union of India, right to reputation is a part of, integral part of right to life and also right to justice. Because if this is not, if these issues are not clear.
There are many matters relating to contest relating to suits of legitimacy, then will, how you will, the probate can be granted. There are many matters. I'll just issue notice and then we'll stay the proceeding.
Yes.
And you are agree basically by the order dated 31/7/2025.
The last impugned order is 31/7/25
yes.
and the next date of hearing is 14/10/25. That is straight after the pujas.
We'll issue notice before that date.
Yes.
The petitioner in person, Miss Srimati Sansita Roy Chaudhary is present. Full stop. She has filed this application under Article 227 of the Constitution of India, read with Section 155 of the Code of Civil Procedure, with prayer to quash the impugned order as a main issue has not been formulated by the trial court. As certain issues have not been formulated by the learned trial court, which is crucial for the decision of the petitioner's case registered as.
And my lord, just a minute. And the other thing is that the respondents are fighting this case from 23 it was filed. They have till date not submitted their documents. And 16(6) order is for documents also, and that has not been reflected in the 31.
This will go back as it is. We are staying this. We stay this proceeding for certain period.
Yes.
So this will go back to its initial stage at the stage of issues.
With the
and then
instructions
they
of the
can
court.
do whatever. Then they can submit their documents if you require some documents. If not, then you will get a good advice how to produce those documents, whichever documents you require. Case number to question PTS number 11 of 2014. Indian, I know case number to PTS 11 of 2014.
24, ma'am.
Oh, yes.
PTS 11,
yes,
24.
2024. PTS 11 of 2024. It appears that it appears nalage. this case is pending at the stage of evidence, full stop, as it is submitted that that certain additional issues are required to be framed, which is crucial for the decision of this case, decision of the original title suit, probate case. Title suit, no probate, it's a probate case.
It's a probate title suit.
Probate case, comma, the proceedings of PTS number 11/2024 is stayed till the next date of listing. Meanwhile, issue notice to the respondents returnable within 4 weeks. Do you want a date?
It'll be preferable, ma'am. if
Date,
we-
let me read it. 14th October,
14th.
before your next date. 14th October.
14th, October is the next date. 14/10.
Oh, 14 আগত দি দিয়ক, 14 আগত দি দিয়ক। September দি দিয়ক।
September.
13 October খোলা আছে নেকি? Yes, yes,
By
13th
speed-
October.
ma'am, I'll send it by speed post, so they'll receive it within 3-4
Yes,
days.
yes. 13th October,
13th.
13th October দি দিয়া আৰু
13th.
by speed post with acknowledgement due.
Huh.
The matter is stayed, you don't worry.
Yes, thank you.
Wait, please, your lordship,
Mm.
kindly pass over the matter for the time being, your lordship. The engaged counsel is on lakes. Mazurus.
May I please touch it? Method fixed for mediation, but we
Yes, yes,
some
just tell
objection.
me if there is any scope of settlement?
No,
your lordship.
No scope of.
Because we challenge the license.
Okay. Learned Counsel, Mr.
El Deca,
El Deca is present for the,
United Indians.
you are the appellant, no?
Yes.
For the insurer, and Learned Counsel, Miss.
I'm appearing for the respondent number 1, 2, and 4
Ah.
as Siddika.
S.
Siddika.
Siddiqa is present for respondent number 1, 2, and 4. First off, it is submitted by the learned counsel for both the sides that there is no scope of settlement and the matter may not be referred to the mediation center. List this matter, it is pending at which stage?
Perhaps after puja, your lordship.
List this matter after 4 weeks.
Yes.
Item number 10.
Maybe, your lordship. Lordship, this is for continuation of delay, 8 days delay, lordship. And already counsel has appeared for the claimant.
No, no. Actually, this is put up for settlement.
But delay has to be condoned, lordship, first.
Delay is not required to be condoned. Put
It
up for
means delay-
settlement for mediation.
The lordship can send the matter for mediation.
Matter cannot be mediated at this moment, your lordship, since we have some consideration with the client. And the amount they are quoting
You
by
are
the,
for the insurance.
Insurance company.
Then we'll fix it for another date, not for today.
Lordship.
another date, your lordship.
Learned
For
Counsel,
orders.
Mr.
Sharma.
Sharma is present for the insurer
Lordship.
and Learned Counsel, Mr.
A. Iqbal,
A. N. Iqbal is present for the
respondent number 1.
respondent number
yeah.
1, 2, and 3. Full stop. The Learned Counsel for the respondents has submitted that there is no element of settlement. And this case may not be forwarded for mediation. List this matter on 15th October.
Oblige.
Item number 11 for admission.
In this case, my lord, already we have,
So this will be highly contested.
yes, my lord.
We will hear you out then.
Very well, my lord, I have.
Otherwise, my lord,
Resist our admission. So what is the point? We will hear you out and finish off the case.
Madam, may dispose it of. I have already argued the petitioner on behalf of the
You
petitioner.
are good
It was already part heard, my lord.
by me.
Yes, my lord.
Okay, okay.
If need be, I can
All right.
provide it.
All right.
That was the, my lord, case, my lord, where amendment was allowed, my lord, belatedly their grievances, that my lord, for not allowing the amendment, my lord, of the counter claim, my lord. But a real question of controversy, my lord.
Okay.
Yes, my lord. That is why I have the judgment. He has already placed some judgment, my lord. But all those judgments, what has been placed by my learned friend, my lord, one religious institution, one is another is, my lord, for after, in spite of receiving the information, they did not file WS, my lord. That was the case. But in our case, my lord, after my lord already handed over the land to them, my lord, after possession of the land, my lord, recovery of possession, subsequently counterclaim was filed. So, my lord, they have got their relief. That is why, my lord, learned already trial court already held here, my lord, saying that, my lord, for ends of justice, it has to be considered. Land has been, because a specific relief act case, my lord, section 6, my lord. So only the possession is the issue. And so far the
This is an action or a revision?
the CRP, my lord.
Okay.
So,
So
my lord,
land has already been handed over to the petitioner.
yes, my lord. Subsequently, I have already placed some judgment, my lord, because, my lord, both parties have some, my lord, dolils, my lord, regarding the purchasing the, my lord, the plot of land, my lord. That is why learned court below, my lord, allowed the amendment at belated stage, my lord. And it is why, my lord, there is judgment also, my lord, 2024 judgment and, my lord, 2022. Here in all the judgment of this honorable court, my lord, this honorable court held that, my lord, if there is a real question of controversy, my lord, it has to be, my lord, amendment has to be allowed. This is one reported judgment, 124, 2024 SCCs, my lord, another is, my lord, our High Court, my lord. Belatedly it allowed, and cost has been given, no doubt, my lord. Here also, in the learned court, trial court already, my lord, given the cost of rupees something, my lord, 9,000 or.
This one 2024 SCC?
Yes, my lord. And another is, my lord, 2009 of this honorable court, my lord. Here also it is.
INSC 2024 INSC 726.
Yeah. GLR I have given one. Oh, yes, my lord. And one is 24 judgment is Supreme Court judgment, my lord.
Okay.
5,000 costs also given. They have the opportunity, they can be able to object it, my lord. After, my lord, this allowing this, they have the opportunity has to be given to them. This is the main issue. Real question of controversy. That has to be, my lord. Only that much.
No, just for the assistance of this court, I'll refresh the facts once. What had happened in this case was the petitioners as plaintiffs had preferred a title suit 125 of 2007, which was preferred with the prayer for seeking possession. Seeking possession. In the very same title suit, the respondents appeared along with others, and they filed their written statement along with a counterclaim. In our suit, we had prayed for recovery of possession based on 2 sale deeds which were executed in our favor by the erstwhile owners. When they filed their counterclaim as well along with the written statement, they prayed for cancellation of our sale deeds, and they stated in the written statement that there were other sale deeds in their favor, and they prayed for declaration that those sale deeds may be declared as legal and operative in this case. The case was heard at length, and thereafter by the judgment, it was directed that the possession be granted to the plaintiffs. Against that very judgment, they preferred a revision petition before this court. In the revision petition, the part of the judgment which speaks about delivery of possession, that is, which speaks about the decree given to the plaintiff in his suit, was upheld, and the case was merely remanded on a limited question of law as to whether there was any right title of interest, as they had raised the counterclaim for setting aside of our sale deeds with regard to those questions, whether there were any right title or interest in respect to which party. The case was remanded. When the case was remanded, since there was no stay of the execution proceedings or the decree, rather it was upheld that the possession may be handed over in favor of the plaintiff. The plaintiffs preferred an execution application before the court. The respondents were all along aware of the execution application. Rather, during the execution application, the execution was satisfied and possession was handed over to the plaintiffs from the respondents. This act, my lord, was done on 7/10/2017. That is way back in the year 2017. And the respondents were well aware about that fact.
That execution.
That execution and that their possession had already been handed over to the plaintiff and they no longer had possession of the scheduled premises. From 2017, they waited till the year 2022, more particularly 9th of November 2022, to prefer the amendment application, seeking for amendments post the execution proceedings. My lord, now if kindly comes to page 70 of the civil revision petition. I'll keep it, my lord, as brief as possible since already I had made my submission before the court.
Page, how much?
70, my lord, 70.
70.
Yes. This is their amendment application.
Okay.
That in view of the developments so occurred after execution of the decree passed in suit under section 6 of Specific Relief Act, the defendants are required to amend their counterclaim for just and proper disposal of the suit and the counterclaims in view of the subsequent developments so taken place. My lord, would kindly come to the previous page, page 69.
Page 69.
69 para 10 onwards.
Yes.
That this learned court as executing court has executed a decree passed in title suit number 13 of 2007 on last 7/10/2017 by delivering the possession of the suit land to the plaintiffs or decree holders. As a result, the plaintiffs are now in possession of the suit land after execution of the aforementioned decree on 7/10/2017, even though the defendants were in possession over the suit land until the execution of the decree so made. This matter shows that they had very well, otherwise they were parties to the execution proceeding, they were present before the court. This also shows that they were very well in the know-how as to when they were dispossessed. But there is an inordinate delay of almost a period of 5 years in preferring this amendment application. But my learned friend has now placed before this court the judgments. It, in my humble opinion, particularly states that if they are able to show that for genuine reasons and despite exercising due diligence, they could not have approached the court prior to the date they have approached in order to seek the amendment. But this is not the case here, my lord. My lord, here after paragraph 14 speaks about their proposed amendments, which is on page 70 of the amendment application, and this continues till page 72. Their proposed amendments regarding the facts of the disposition and 2 prayers. One regarding decree of declaration that the defendant numbers 1 to 9 have right title interest over the suit land in schedule B and C. Right thereafter, my lord, from paragraph 15 onwards at page 72, if my lord kindly has it.
Yes, sir.
That the defendants beg to submit that the grounds so stated herein are just and sufficient for amendment of the counterclaim as proposed. 16. The defendants beg to submit that the amendments of the counterclaim have been warranted to be made just and proper disposal of the suit and the counterclaim due to subsequent developments of the subject matter of the suit that have taken place after execution of the decree passed in the suit under section 6 of Specific Relief Act 1963 as stated above. As such, there is no legal bar in allowing the amendment of the counterclaim as proposed. Next page, my lord. The defendants undertake to pay the requisite court fee. My lord, here they have nowhere stated as to why within the period of 5 years. I understand they are asking for equitable relief before the court, seeking amendment with regard to a subsequent fact. But even in that scenario, my lord, they are to show their bona fides and show the reason of their delay as to why they could not approach this court within the prescribed period of time. Now, my lord, this my lord comes to page 82, that is the impugned portion of the impugned judgment.
Page 82.
82, my lord.
Yes.
What is the last paragraph? I'll get rely on that, page 82. At the same time, my lord has it. At
You
the
have
same
showed
time,
me this earlier also.
I've shown this earlier, my lord, just to show the fact that the trial court had also observed that there was nothing on record to show that there was an inordinate delay of 5 years, and it was never explained. In the present case, the suit has proceeded to the stage of filing of PWs, thereby meaning that the trial of the suit has already commenced. And after the amendment of Rule 17 of Order 6, it has clearly been shown, it has clearly been provided that after commencement of trial,
Yes,
after
yes, there's no.
that
Go on,
part,
amend, yes.
this submission also I have made, my lord, my only point is that though they state that it is an equitable relief on the grounds of equity, they are to be granted, but have they shown their bona fides before the court? First and foremost, have they discharged the burden which is cast upon them as per the proviso to Rule 17 of Order 6, wherein they are supposed to show their due diligence for not approaching the court on an earlier time? Secondly, when in the impugned order, when the learned trial court already observes that there has been from records, there has been no explanation as to the delay of nearly 5 years. Was it judicious on the part of the learned trial court to allow this application without there being such adherence to the provisions of Order 6, Rule 17? Secondly, my lord, I had also argued on the last date that they have provided the amendment sought to introduce a time-barred claim, which as per the judgment which I had relied on last date is 2022 SCC Online 1128 at para 70. Amongst various postulates, it has been shown that a time-barred claim cannot be sought to be introduced by means of an amendment. This would be completely against the principles of justice. Because the claim here regarding the declaration of right, title, and interest, which was available to them from the very date they had filed their written statement, that is in the year 2015. But they chose
You
not
are
to.
referring to one Supreme Court judgment, which is it?
My lord, 2022 SCC Online 1128. The copy I had already furnished on the earlier occasion. I
SCC Online 1128.
1128. If the copy is not available on record, I can furnish
It's
another.
okay. Okay, we'll conclude.
Yes. After this, just I want to point out only one line, my lord. This after disposition point, my lord, this amendment petition has been filed, my lord. Specifically mentioned that no for recovery of possession, etc. It will come later on, my lord. Because my lord already handed over the possession. That is why, my lord, it has been added, my lord. Counterclaim filed prior to that, my lord, in the year 2017 itself. Subsequently, for amendment, petition has been filed only because of the ground that, my lord, that prayer already possession has been given. Again, get back the possession, mention it is, my lord.
But
That is why Lanet could be possibly allowed.
No, it is nowhere informed that the amendment was not after filing of the counterclaim. The only purpose, the only submission is that they said amendment was sought for after a period of 5 years, that too without any explanation in the petition. And in that scenario, when it has been clearly recorded by the Lanet trial court, whether or not it is liable to be allowed, coupled with the fact that there is a time-barred claim.
In his judgment also, my lord, is specifically mentioned, my lord. All the amendments are to be allowed, which are necessary for determining the real question of controversy, provided it does not cause injustice or prejudice to the other side. Obviously, they have the opportunity, my lord. Objection also filed, my lord. That was not.
Partial reading of the judgment begins with the said line, but thereafter also comes to the point that the amendment does not raise a time-barred claim resulting in divesting of the other side of a valuable accrued right. Where the amendment merely sought to introduce an additional or new approach without introducing a time-barred action, the amendment is liable to be, if it does not introduce a time-barred action, which in this case is being done.
Our learned counsel, Mr. N. Chaudhary, and learned counsel, Mr. For the, this is petition, no, for the petition, and learned counsel, Mr. H. Das for the respondents, reserved for judgment and order. It is very, in my belief. Day to be dia, sir. Itu belega ta jinsi.
Item 12.
My lord, the matter may be passed over for the time being, my lord.
Lordship, I'm seeking for an adjournment, Lordship. Today I'm handicapped, Lordship. My brief has been left out in chamber, Lordship. If the Lordship, next week, any day?
Sir, Mr. Your name?
P. Mojumdar.
P. Mozumdar has prayed for adjournment. List the matter on after vacation.
17th.
Do admission, right? After vacation.
No, my lord, can it be next week, my lord? So, they are seeking that.
After vacation,
No, we have urgency in this matter, that's why we have mentioned it, lordship.
the 17th September,
Oblige, Lordship.
When, lordship?
17th September.
17th September.
Oblige.
This is an injury case. I'm willing to deposit 50%, Lordship.
I may be allowed to withdraw the money. That will come clear.
Our learned counsel, Mr. R. Goswami, for the applicant. And learned counsel, Mr.
AB Day.
AB Day for the respondent number 1.
Well,
The applicant is agreed by the judgment and order rejected.
Last is 279. Then it's okay.
Judgment and award. Judgment and award dated 26/5/2022 passed by the learned member MSCP Future Kachar in connection with MSC case number 1385 of 2016. The applicant has prayed for stay of the impugned judgment and order. Full stop. I have considered the submissions at the bar. Full stop. The impugned order dated 26/5/2022 is hereby stayed, subject to the condition that the applicant deposits 50% of the compensation amount within 4 weeks before the registry of this court. Full stop. The learned counsel for the respondent has submitted for withdrawal of the 50% of the compensation. Full stop. The respondent is allowed to withdraw the compensation after executing a bond for verification by the registry. In terms of the above, all the matter stands disposed of. In terms of the above observation, matter stands disposed of. मैं कैपिलर के एक reply admit लिखी दिया. Issue notice to respondents returnable within 4 weeks. A हेरी वो लिखिबो ना लागे.
My lord, LCR may be called, my lord.
Huh?
LCR
Oh,
may be
yes,
called.
yes, yes. Call for the trial court records. Yes.
Deeply.
List accordingly. Returnable within 4 weeks.
May it please, this matter may be taken up on Wednesday, my lord.
Wednesday.
Wednesday.
Wednesday, how was no time? No.
Or Thursday, my lord.
Next week. Next
thing,
week.
my lord, because execution proceeding has already been started, my lord, that may be stayed, my lord, because that is an arbitration appeal under Arbitration Act 1940, my lord. Arbitration appeal, my lord.
My lord, otherwise this issue has already been decided by the Honorable Supreme Court.
That is, I have annexed, my lord, let them hear, my lord. I have annexed the order of the Supreme Court also, my lord. This week, my lord, any day.
The Wednesday, Thursday, my lord, no problem.
11 September.
Yes, must have.
Is this matter on 11 September?
Lordship, this matter cannot be settled in mediation. And also there's an order for submitting the amended cost title, which has not yet been filed. So I'm praying for some time to file the amended cost title.
Lordship. Learned Counsel, yes.
I'm for response number 3, Lordship.
Learned Counsel, Mr.
H. Buragan.
H. Buragan is present for the appellant and Learned Counsel, Ms. M. Chaudhary
Lordship.
is present for respondent number 3. Full stop. The Learned Counsel for the applicant, appellant has submitted that that there is no element of settlement in this case, and this case may not be referred to mediation. List this matter after vacation.
For striking out.
After puja vacation.
Mission to legal. So also there should be an order for substituting the and for submitting the amended cost title.
You pass, file an amended petition.
Must oblige, Lordship.
May I please, my lord, as per office note dated, my lord, trial court reports are not received, my lord. And my lord, my friend is directed to take instruction with regard to service, my lord. This is a POXO matter, my lord.
Lordship, to that regard, regarding service of report, Lordship, we have sent her intimation on 22nd 08, Lordship. Till date, no report has been received. And in the meantime, Lordship may call for the TCR also.
Okay. Trial court record, trial court, scan copies of trial court records as called for is not received. Learned additional PP, Ms. S. Bora has submitted that they have not received any information relating to service of notice to respondent number 2. Full stop. Service of notice to respondent number 2 is just waited. List 21.
Before vacation at least, ma'am.
19 September. List this matter on 19th of September.
Wait, the medical report was called.
Lordship, otherwise, Lordship, 183, 181 BNSS statement, Lordship, of the victim, along with the seizures witness victim statement, Lordship. There's certain allegations against the petitioner that has been proved, sufficient materials against the petitioners. This is a gang rape, Lordship. In the meantime, Lordship, medical report was called for regarding the Visara, Lordship. That is not, that is awaited, Lordship.
Obliged.
Obliged.
Is your Lordship, she may take the matter after some time.
Item 18.
Second appeal is against reversal, my lord.
By appellate court?
My lord. My lord, the appellate court judgment, my lord, can you see?
Yes, please read the appellate court judgment.
It starts from page 136, my lord. And the operating part, my lord. Operating part is page 159. Operating part, my lord, judgment 159. Points for determination in the appeal, whether the finding of learned trial court that shall be dated 24/8/90 is illegal.
No,
null
no,
and void.
no.
My lord.
You'll read the findings. You'll read from the findings or else I'll read from the findings.
Yes, my lord. I am reading the finding. Only it's for 2-page findings.
Yes.
That is the two points of consideration, my lord. So in point.
No,
in-
I'll find out from where to read.
Hmm.
I'm sorry to say, but I'll have to read it alone because you'll have to read from page 141.
My lord,
You'll have to read from page 141.
my lord, 149, there could discussions regarding pleadings. both
Yes,
parties
I'll have
could
to
be-
read
yeah.
it, no, because I have to frame a substantial question of law. I'll have to read it. So whether either you read it or I'll read it.
It has been,
I will have to read it.
my lord.
Who'll read it?
Full judgment. How to start it, madam?
I'll read it. You sit down, I'll read it.
All right.
I'll come back after 5 minutes. Yes, sir. You wanted to read from page 159.
Well-
You wanted to read from page 159?
Yes, madam.
Yes, you can continue from page 159.
So,
Yes.
may say the operating part of the judgment, madam.
Yes, yes.
Operating part of the judgment, madam. So, madam, the first appellate court has shown 2 points of consideration, madam. 2 points for the sir. Whether the finding of learned trial court that sternly dated 24/8/90 is illegal and null and void and liable to be set aside. And number 2, whether learned trial court declared the sternly dated illegal, ineffective, null and void and ineffective on 2 grounds. Firstly, that the sale deed was effected during the continuance of injunction. Secondly, the same was executed in violation of existence of agreement of sale. So trial court has declared that the sale deed executed by defendant 1 in favor of the defendant 2 and 3, that was illegal and void because those sale deeds were executed during pendency of an injunction order. Order of injunction was there. So during that order of injunction, the sale deed was executed. Second, so now the court came to the finding that firstly, that the said injunction at the outset, the court is of view, coming to the first ground, that's aforesaid observation of learned trial court that sale deed was affected during continuance of injunction order is perverse in the record. The said injunction order passed in TS number 250 has not been proved in the instant suit, and as such, no cognizance of said order can be taken in the instant suit. Firstly, the court said that that order was not exhibited in evidence. So, say then, now the learned.
Because it was a decree of compromise, that is why.
My lord, actually what happened, they have the defendant were the pro forma.
I know the story.
Yes, yes. So they have filed a suit. Pro forma defendant 4 and 5 have filed a suit.
I know.
Yes,
That
they
is
have filed-
the entire story.
in the said suit, they have obtained an order of injunction, restraining the defendant number 1 from
That
entering
is I
suit.
know.
So during pendency of the suit, during pendency of injunction order, they have firstly sold the suit.
Yes, yes.
After selling the suit land, they come forward to the court to say that we have compromised the matter. Now this we would want to withdraw the suit. So if they could have sold the suit land after withdrawal of the suit, then there would not have been any suit. But they have, because after withdrawal of the suit, the injunction order is also.
It is same. Withdrawal and compromise is same.
Yes, same. They have withdrawn the suit, but if the sale deed is executed after compromise or after withdrawal of the suit, then there will not be any issue because injunction is gone. One suit is withdrawn or one suit is dismissed, all interim orders vacated.
They have compromised, no? It is as good as withdrawal.
Right. So, but what they have done, they have executed sale deed during existence of the injunction order. So that is violation of the order. So according to Supreme Court decision, my lord, may kindly see that.
No, it's okay. It's okay.
My lord.
It's okay. I understood.
So that first point is that my substantial question of law is that the order of injunction was there, in violation of order of injunction, sale deed was executed. So that sale deed is.
Yeah, give me the decision.
Then what is the finding of learned trial court?
No. You give me the decision.
Right.
On substantial question of law, you have raised one question of law, that the appellate court has held that that sale deed is valid while it was executed at the time when the injunction order was in force.
Yes.
So appellate court has held like that, but trial court has held the opposite. So this is your substantial question of law. So give me a decision in the Supreme Court. Only this, I'll frame only this.
Another
question.
is there. Another is there, my lord.
Another question.
My lord, another question of law is there. Another question of law is there, my lord.
No. See, I'll frame only this substantial question of law.
My lord, just Mr. Another question of law. What is another question of law, my lord? Very important, my lord. The learned trial court, first appellate court says that the defendant in the suit is protected by Section 19B of Specific Relief Act. My lord. Section 19B is bona fide purchaser with consideration, without notice of previous agreements. So, my lord, that plea has to be taken by the defendant in their pleadings, and the defendants are required to prove it. But in fact, in this case, the defendant has neither taken that plea in their WS nor they have proved it. So that cannot be taken into consideration, my lord, because that was my
No, but it was held by the appellate court.
my lord.
It was already discussed. Section 19B of the.
Section 19B, but the appellate court can.
It was already discussed by.
When the section 19B only comes if it is in pleading of the defendant. This defense have to be taken by the defendant. Defense to be taken by the defendant. If the defendant does not take the defense, that cannot be. My lord, the specific decision, my lord, 19B, it has to be pleaded and proved. My
Okay,
lord,
this judgment.
only these two judges.
Jehal, Tati and others, which,
My lord, it is regarding that.
which
the-
one?
It
Which
is regarding,
paragraph?
my lord. My
Which
lord,
paragraph you are
I
referring
am marked,
to?
my lord.
Paragraph
I think that was marked, my lord.
11?
I have
You
only
marked
one
the
copy.
paragraph.
I had only one copy, my lord.
Okay,
Two
okay.
paragraphs, my lord. There are two.
Paragraph 11?
Yes, 11.
I'll just read it.
My lord,
I'll just read it.
my lord.
Okay, I'll ask them this one question of law and then the other.
The other.
Only these do not
I
know.
don't know. Only.
On which page have you framed the substantial questions of law?
My lord.
Proposed substitution, purported substitution, substantial questions of law.
My lord, I so.
This judgment, which paragraph?
My lord, it is page 5, my lord.
Page 5. No, this relating to section 19B of Specific Relief Act, which paragraph?
My lord. My lord, it is para 4.
Okay. No, there's nothing about that including in the written statement.
My lord, there is no pleading, my lord. That my lord,
No,
my
but
lord.
it's not, there's nothing in this paragraph about impleading section 19B, the fact about section 19B in the defense statement. It's not required.
My lord, there probably, my lord, I am very sorry, my lord. I have only one copy. I could obtain only one copy. That much I said specific point of view. I said specific point of view. I shall read over, my lord. May we be allowed to read over?
Yes, sure.
I should have obtained 2 copies, my lord. Very sorry, my lord. My lord. My lord. Section 4, Section 19 of Specific Relief Act, as can be seen from Section 19A and B, extracted above, specific purpose of contract can be enforced against either party thereto, and B, any person claiming under him by a title arising subsequent to the contract, except a transferee for value who has paid his money in good faith and without notice of the original contract. Section 19B protects the bona fide purchaser in good faith for value without
It
notice.
protects, yes, it's true, but
Well,
that you have to mention in the.
This protection is in the nature of exception to the general rule. Hence, the onus of proof of good faith is on the purchaser. On the purchaser means the defendant who takes the plea. That means he has to plead it. That
Yes,
he
yes,
is
you
an innocent
please mark the
purchaser.
paragraph.
My lord.
I'll read it. So these two questions, where do you have framed?
Well,
Formulated in your memo?
At page 5, my lord.
Page 5, which one? There are so many substantial
My lord,
questions.
my lord may take the point number 4.
4, yes.
Point number 4 and point number 2.
2 and 4.
my lord.
Okay. Okay, all right.
My lord.
Third learned S. Sharma.
Yes, sir.
Third learned counsel, Mr. S. Sharma, for the appellants who have filed his appeal under section 100 of the CPC against the judgment and decree dated 24/7/2025 passed by the learned additional district judge number 1 Kamrup Metro in connection with TA number 6 of 2008 reversing and setting aside the judgment and decree dated 26/9/2000 passed by the learned civil judge senior division number 1 Kamrup Metro in TS number 10 of 1991. This appeal is admitted on the following substantial questions of law, page 5, 2 or 4. Issue notice to the respondents, call for the original records of TA number 6/2008 and TS number
250, my lord.
215,
250, 250, my lord.
250 of 2000,
1988.
1988.
Along with my lord, PS 10 one, my lord.
No. 250 is not required.
250 entire in the.
That is a different case. TS 10 of 1991.
Right.
250 unlike TS 10 of 1991. Why should we bring the different case from the respective courts? Issue notice to reconcile within 4 weeks. Issue notice to list accordingly.
My lord. File one IA is there, my lord.
I
My lord, for operation of the
No, we'll take a later. We'll take a later.
I will be on next date, my lord.
Next date, yes.
Item 20.
Please, Lord, sir, the senior counsel is on like kindly pass the matter for the kindly.
After some time, but
21.
May I please, Lordship? My appeal was dismissed on default. And this MSC is filed for restoration of that appeal, Lordship. In fact, Lordship, that appeal. The Lordship will.
which one? Make appeal number 581/22.
581/2022. And in the cause list, Lordship, my name was not shown. In fact, my other two colleagues' names were.
Actually, you were absent on 2 dates. That is why it was dismissed.
Yes, Lordship, on both of the days, Lordship, my name was not shown. I have an exact cause list, Lordship. Page 12. Page 12 in the top, Lordship. In fact, we are, Lordship, serving the case by our name, Lordship, by name of M. Khan, but that was not shown in the cause list. That's why, Lordship, this was dismissed. So it will be restored, Lordship.
Yes.
Have no objection, Lordship.
Learned counsel, Mr. M. Khan is present for the applicant. IA number.
No, this
20
case.
Miss case 29 of 2023 is present for the applicant, and learned counsel, Mr. Arsharma is present for the insurer. It is submitted that the appeal was dismissed on default as the learned counsel's name was not reflected in the cause list,
yes,
which is marked as annexure 11 of this application. The learned counsel for the respondent has no objection. The appeal number or the MAC number 581, 2020, within bracket D stroke O is hereby restored to file.
But in the appeal lordship else, trial court record me call for lordship.
Let it get restored to
Yes.
file, then we will call for trial court record.
Lordship is that
22.
my lord restores.
Ah,
My lord appeal may be directed to be listed after a with lordship.
it is restored to file already, it will be restored to
Yes.
file.
Obliged. My lord.
Mm.
I'm for the respondent,
Mm.
1328.
1328.
Yes, 1328.
Okay.
328.
This has come after first time, after 2013.
What did this is listed?
Miss case 1491.
It was listed on 2215, 13515,
Just a moment.
and 19422.
Which case are you taking up?
20.
I know, but case number?
RSA 224 2010.
Yes. RSA 224 2010. Okay.
The main case was listed.
Mm.
Today I have seen the flag mark. There's some complaint filed by the appellant
Mm.
against us, but we are not. I've taken instruction from a client that there's nothing happened. There's some complaint filed to the Chief Justice. The flag mark. The appellants and the respondents are the family members. The appellant is the son and the son's family, and the respondents are the daughter's family. Maybe so it is listed. You are filing any petition for this honorable court. They have written a letter to the Chief Justice.
They are not present also today.
Yes. The appellants and the respondents are co-shares. Property belonging to one Tahib Hussain. They claim that the father has all the right, and respondent got his.
And was this appeal disposed of? No.
No. It was admitted and fixed for hearing.
It I took likhiba, huh? Miss case 1491 2013. The applicant the applicants are not present. Learned Counsel, Mr.
SR, I'm for a respondent.
SR, I know.
Hmm.
SR Gogoi
Yes, sir.
is present for the respondents to opposite parties. And the connected RSA is listed for hearing. However, it has been brought to the notice of this court that despite the order of this court directing both the parties to maintain status quo, and not to create third-party interests, there has been a violation of the order of the status quo. The learned counsel for the respondent has, however, denied any violation of any of the violation of the order dated 16/12/2013 passed by this court. RSA लिखी दिया. The appellants are not represented today. Learned Counsel, Mr. H. Gogoi, no?
SR Gogoi.
SR Gogoi is present for the respondents. Full stop. List this matter for hearing positively on data DDR. Failing which necessary orders may be passed.
Right.
No, dispose nahi. You dispose ko nahi.
All right.
Standing item 16 and 17 for hearing under rule 49.
May it be the lordship. In this case, appellant is the plaintiff, lordship. He filed a suit claiming right title interest on the basis of adverse possession, lordship, to which the defendant number 2 filed counterclaim claiming right title interest on the basis of registered
same suit land.
Same suit, lordship.
But on the basis of registered sale deed.
Registered sale deed. For that, lordship, I have filed 2 regular second appeal as his counterclaim was allowed and my suit was dismissed. So 2 regular second appeals against the same judgment.
Concurrent judgments.
Concurrent judgment, lordship. Defendant number 1, lordship, is the owner of the, first he was the owner of the said plot of land. He handed over possession of the entire plot of land to the appellant, lordship, just to look after the entire plot of land as a caretaker, and then he allowed B scheduled land to be possessed by me on a condition that I will later on register a unregistered, later on I will register a gift deed in your favor. Accordingly, a unregistered deed was executed, but it was never registered, lordship. So as per Hindu law, it has no validity in the eye of law. But from the date of unregistered deed, I am claiming adverse possession on the said plot of B scheduled land, lordship. On that basis, I filed the suit for right title interest over B schedule only. And I am saying that, lordship, when unregistered gift deed was executed, the defendant number 1 has no possession, no title over that plot of land. So he could not sell out the entire plot of land to defendant number 2. And that was admitted by defendant number 1 also in his written statement.
See here. See, I'm just cutting short.
Lordship.
I'm just cutting short your argument.
Lordship, kindly.
I'm just cutting short your argument.
Lordship.
I don't think you have a case here. You are under permissive possession.
No, lordship, my case is that I am an adverse possession. I am taking adverse possession plea over B schedule.
No, you cannot take because you have an unregistered sale deed in your favor.
Lordship.
So you don't have a case here.
When I asked him to, lordship, register the sale deed, then the defendant number 1 denied, and from that date I am claiming adverse possession. Since
And
that date,
when is that date?
First part of 1990, and suit was he registered the sale deed in the year 2003.
Even then, I don't think you have a case.
Lordship, I will satisfy that as per Supreme Court, lordship, plaintiff can claim right title on the basis of adverse possession, and
that can be claimed.
Lordship,
I know that much I will agree, but when you have permissive possession, can you claim right title and interest on adverse possession?
When he refused to execute the registered gift deed, lordship, From that part.
Once you are given permission to settle, and once there is an unregistered sale deed.
And defendant number one also filed a written statement saying that I have executed the registered sale deed in favor of my brother on the basis that he will not disturb the possession of the plaintiff. But he misguided and thereafter he executed the sale deed over the entire plot of land. So defendant number one is also admitting my case, Lordship.
What is, come again, defendant number one?
Defendant number one. Owner
What
of the
has
property.
he stated?
He stated that I have executed the registered sale deed in favor of defendant number two, my own brother, saying that, Lordship, that B schedule land, he cannot evict the defendant number plaintiff from that schedule, and he only purchased the rest of the land. But he misguided me and he executed the entire sale deed over the entire plot of land. That is there in his written statement. So defendant number one.
Just show me the written statement.
Page 16, Lordship.
Only that, please.
Lordship.
Page 16.
Milan Hazarika, defendant number one, he is the owner of the property. Page 15, the written statement by him, and relevant portion, page 16, Lordship. Paragraph 6, Lordship. That it is not.
He is, Milan Hazarika is?
Owner of the property, Lordship.
Owner. He is the brother?
To brother, he sold out the property, Lordship.
He sold this property to his brother?
Yes, Lordship. Okay. That it is not true as stated in para 4 of the plaint that this defendant with any ulterior motive executed registered deed of sale of 1 bigha 1 lessa of schedule A suit land in favor of the defendant number 2. The defendant number 2, who is own brother of the defendant number 1, wanted to purchase his share of 4 katha 1 lessa, that is part of schedule A suit land, from this answering defendant, and accordingly as he himself has 1 bigha 1 lessa of land in the said Dak and Patta. So the defendant number 2 at his own initiative instance got the sale deed written at the Tezpur court and thereafter called the defendant number 1 to the office of the sub-registrar Tezpur, who was then in service duty at the office of the executive engineer Assam State Electricity Board, Tezpur. This answering defendant accordingly went running to the court and signed the said deed of sale as the defendant number 2 assured not to disturb possession over 1 katha of schedule B land which was being possessed by the plaintiff since October 1990 by virtue of the unregistered deed of gift made to him by the answering defendant, by saying that he, the plaintiff, is his defendant number 2's own nephew also. It is also submitted by the answering defendant that the sale deed got executed by the defendant number 2 in his favor from the defendant number 1 was an act of fraud and misrepresentation made by the defendant number 2 and beyond the will and intention of this defendant, and this defendant was paid money value by the defendant number 2 in respect of only 4 katha 1 lessa of land out of sale consideration of rupees 40,000 only. The defendant number 2 actually paid an amount of rupees 36,000 and remaining 4,000 only has not been paid yet, was fixed as value of measuring 4 katha 1 lessa. As the suit schedule B land was in occupation of the plaintiff since October 1990 by enhancement of the land, the possession thereof was not given to the defendant number 2 as it could not also be given due to the fact that the schedule B land was in possession of the plaintiff, who also declined to give possession to the same to the defendant number 2. So it was within the knowledge of the defendant number 1 that I am possessing the plot of land, Lordship. Irrespective of that, he denied to register the sale deed. That pleading is also there in my plaint, Lordship. So from the date of possession of my possession over the B schedule land, Lordship, their counterclaim is not maintainable as it is barred by limitation, Lordship. Paragraph 4, page 8, Lordship.
That your plaint?
Yes, Lordship. Paragraph 3 and 4, I have taken my adverse possession plea, Lordship. Paragraph 3, page 7.
Yes.
That the plaintiff accepting the gift from the defendant number one, he entered into the possession of the one kata of land on as mentioned in the Schedule B of the plaint, along with the remaining portion of the Schedule A land on 5/10/1990, and he constructed his residential house thereon within a month with kacha structure. After construction of the residential house on the plaint Schedule B land, the plaintiff in the last part of the month of October 1990 requested the defendant number one to execute a registered gift deed in his favor in respect of one kacha of land out of the total land measuring 1 bigha, 1 lessa as mentioned in the Schedule A of the plaint, which the defendant number one refused to do so. So I have approached.
Okay, you are from this date, you are claiming adverse
Lordship,
possession.
adverse possession.
Earlier you were in permissive possession, now you are claiming
Now I
adverse
am,
possession.
he refused to execute the registered gift
Yes,
deed.
I got your
then
point down.
Lordship. So I am claiming from this date, it is within the knowledge of the defendant number two also that I am in possession. So his counterclaim is barred by limitation, and there is no bar in claiming right title interest on the basis of adverse possession by the plaintiff. But the learned trial court and first appellate court held that plaintiff is not able to show adverse possession in respect to defendant number two. And his unregistered deed is the counterclaimant lordship claimed that my unregistered deed is void, fraudulent. Both the courts held that my unregistered deed is not void, fraudulent, but it has evidentiary value. But as it was not registered, so it does not confer any right title in favor of the plaintiff. So these are the findings by both the courts below, lordship.
Where is the finding? One finding will be enough, appellate court finding,
Lordship.
because it has it has upheld
Lordship, I am reading RSA number 68, lordship.
yeah, 68. Which page?
Lordship.
The finding?
Trial court judgment, lordship.
Easy to understand, of course.
Trial court judgment page 72, lordship. Issue trial court judgment, lordship, page 83, annexure 7.
Yes.
Issues your lordship.
We'll continue after break.
Lordship.
Yes. No problem. We'll continue after.
Formulated by the first appellate court,
Mm.
page 130.
Mm.
Whether learned Munsif number 1 Sunitpur Tezpur rightly decided and answered the issue number 5, 6, 11 and 12. Whether learned Munsif number 1 Sunitpur Tezpur rightly dismissed the suit of plaintiff appellant, further rightly decreed the counterclaim of defendant number 2, providing sufficient reasons. Whether learned Munsif number 1 Sunitpur Tezpur appreciated the evidences adduced by both sides properly, leaving no stone unturned. Whether findings of learned Munsif number 1 Sunitpur and Tezpur are based upon lawful consideration and settled provisions of law. Lordship, issue number 11 is important. 6, I am not reading. Issue number 11, paragraph 31, Lordship. Page 140. Now coming to the question raised regarding the validity of the sale deed number 688/2003 as well as right of the defendant number 1 to execute sale deed in favor of defendant number 2 by registered sale deed number so and so. This court finds that PW1 deposed that in March 2003, the defendant number 1, due to his ulterior motive, without having any possession rightly and right and authority in respect of 1 katha of land, out of the total land measuring 1 bigha, 1 lesser land of plaint Schedule A, behind the back of the plaintiff executed a registered sale deed in respect of entire land of the Schedule A of the plaint in favor of the defendant number 2, white registered sale deed number 688 of 2003, executed in office of senior sub-registrar so and without delivery of possession of the land to him. PW1 testified that defendant number 1, on the basis of the aforesaid sale deed in collusion with the concerned lot mandal of Tezpur revenue circle, got his name mutated in respect of the entire 1 bigha 1 lessa of land as mentioned in the plain schedule, although he certainly has no possession on plain schedule B land. nor acquired any good title on the same by the aforesaid sale deed from his vendor, who prior to execute the sale deed had extinguished his right title interest by operation of law of limitation. PW 234 in their evidence have deposed that defendant number 1 has sold 4 katha 1 lessa of land to defendant number 2, keeping aside 1 katha of gifted land to plaintiff, which is contrary to the evidence of PW 1, who alleged that while registered sale deed number so-and-so executed in the office of senior sub-registry officer, Tezpur, defendant number 1 sold schedule A land to defendant number 2. PW 23 deposed that defendant number 1 has sold 4 katha 1 lessa of land, but the defendant number 2 got entire suit land registered in his name. Here in this case, learned First Appellate Court Lordship said that I have admitted the sale deed, but from the pleading I will show to your Lordship that from plaint I have said that behind my back defendant number 1 fraudulently executed. So I am denying the execution of exhibit, Lordship, that is registered sale deed. But counterclaimant prove that registered sale deed while exhibit A, that is certified copy. There will arise another substantial question of law whether counterclaimant is entitled for right title interest on the basis of certified copy of sale deed without exhibiting the original deed, Lordship, in his favor. When there is a denial from the plaintiff, Lordship. I am denying that there is a fraudulent activity cause, Lordship. The defendant number 1 fraudulently executed the sale deed. But the learned trial court, First Appellate Court, both the courts are saying that I am admitting about the registered sale deed. Yes, I am admitting, but I am saying that it was executed behind my back, Lordship. Yes, para 42, Lordship, hence it has.
I just lost the page.
Lordship, page 140.
140.
140.
140, yes.
Last paragraph, Lordship. Hence, it's seen that evidences are inconsistent with the plea of PW 1, who deposed that defendant number 1 sold entire land, meaning thereby that defendant number will fully sold schedule A land without having right to sale. The said plea of plaintiff appears to be not tenable since the PW 1 in his cross-examination admitted that after knowing about the sale in the year 2003, he has not done anything for cancellation of sale deed and mutation in the name of defendant number 1. Since no action was initiated by the defendant number 1, hence they impliedly admitted the same to be genuine. DW1 has exhibited the copy of certified copy of sale deed as exhibit A. So original was not exhibited, Lordship. Jamabandi copy of the suit land as exhibit B and the land revenue paying receipts as exhibit C, D, E, F. DW1 exhibited mutation certificate as exhibit H and certificate from Mojadar. All the aforesaid documents prove that defendant number 1 has sold suit land in favor of defendant number 2 and suit land has been mutated in his name. Lordship, to prove his right title, he ought to have exhibited the original sale deed and without taking permission from the learned court below, Lordship, that was exhibited the certified copy of the sale.
Not according to section 67 or 65, I think.
Lordship. And Lordship, moreover, it was said that at the time of exhibiting the sale deed, there was no objection by the plaintiff. So it was taken to be proved, Lordship. But there is complete allegation by the plaintiff in regard to execution of exhibit A, Lordship. To sum up the oral as well as documentary forms of evidences, this court subscribed to opine that plaintiff appellant failed to prove that sale deed number so-and-so is fraudulent, void, inoperative, and furthermore, defendant number 1 having his right title and interest over the suit land rightly executed the suit property described in plaint in favor of defendant number 2. Hence, the discussion and decision of learned trial court below in respect of issue number 6 and 11 not deserve any interference from his part appellate court and consequently the same is upheld. So this is the finding of the first appellate court and issue number 5 and 12, which ought to be 12. Issue number 5 relates to the fact that as to whether the plaintiff acquired right title and interest over suit B land by way of adverse possession against the defendant number 1. Issue number 12 relates to the fact as to whether the plaintiff is permissive possessor of the suit Schedule B land under the defendant number 2. Learned Trial Court decided and answered issue number 5 in negative against the plaintiff, and in favor of the defendant counterclaimants. Further, Learned Trial Court answered issue number 12 against the defendant number 2, holding that plaintiff is not permissive possessor of defendant number 2. Now, in the forthcoming discussions, this first appellate court shall try to ascertain whether the discussion and decision of Learned Trial Court below, based upon the true factual metrics of the case and further based upon the true sense of appreciation of the Learned Court in respect of evidences presented by the rival parties during the trial. Certainly, the plaintiff appellant in his pleadings pleaded that defendant number 1, being original owner of Schedule A land, executed sale deed number so and so in favor of defendant number 2. Plaintiff further pleaded that long before execution of alleged sale deed, he acquired his right, title, and interest by way of adverse possession, since he has been in possession over the land openly, uninterruptedly, and adversely against the defendant number 1 from the year 1990. The plaintiff appellant further pleaded that defendant number 1 gifted him 1 kata of land by executing an registered gift deed out of Schedule A land of plain, and further asked him to look after the remaining land of Schedule A along with 1 kata of land and delivered the possession of entire land 1 bigha 1 lessa in the year 1990. The plaintiff appellant at the time of adducing evidence exhibited the alleged unregistered gift deed to be Exhibit 1, and defendant number 1 in his written statement admitted that he had executed an unregistered gift deed in favor of the plaintiff, but subsequently he was not interested to register unregistered gift deed in favor of the plaintiff. And about this unregistered gift deed, Lordship, both the courts held that this is valid, not void, as claimed by the defendant number 2. So it is existing in the eye of law.
No, but you cannot,
unregistered, so it is not.
you cannot claim it because
Lordship.
one is just unregistered, another is you are claiming
Lordship,
adverse
my vendor
possession.
is also admitting both the courts also held that it is a valid
But you are
unregistered
claiming
gift.
adverse
But as
possession.
it is not unregistered, so this gift deed cannot confer any right title on the plaintiff. But on the basis of that gift deed from that date also, Lordship, I can claim adverse possession. It can be used as a piece of evidence to show my possession from the date.
No, you cannot use it for adverse possession.
At least from the Lordship.
No, you cannot use it. No.
For collateral
For permissive
purpose.
possession, yes, but not adverse possession.
Lordship, and pleading also, I am saying that since the month of October 1990, I approached him and he refused. And defendant number 1 also admitted that I refused to register the sale deed. So from that point of time also, I can claim my adverse possession, Lordship.
Maybe.
Lordship.
Let's see.
The plaintiff appellant at the time of adducing evidence exhibited the alleged unregistered gift deed to be Exhibit 1, and defendant number 1 in his written statement admitted that he had executed an unregistered gift deed in favor of the plaintiff, but subsequently he was not interested to register unregistered gift deed in favor of the plaintiff. Now question is whether an unregistered gift deed pertaining to Schedule B land gives any right title interest to the plaintiff over Schedule B land. In view of Section 17 and 49 of the Indian Registration Act, an unregistered deed is not admissible in evidence. Furthermore, Section 122 of Transfer of Property Act defines gift as transfer of certain existing movable and immovable property made voluntarily and without consideration by one person called the donor to another called the donee, and accepted by or on behalf of donee. Section 123 of the said Act also provides that gift of immovable property must be effected by registered instruments signed by or on behalf of donor and attested by at least 2 witnesses. Section 123 does not lay down the precondition of possession for validity of gift. As per Section 123 of Transfer of Property Act, gift deed between Hindu parties compulsorily registered irrespective of its value of property. In the present case, admittedly, the gift deed was unregistered, hence no title can be passed on plaintiff. It is also settled that if any person acquires any possession on the basis of unregistered gift deed, then he cannot defend his possession on the basis of unregistered gift deed, since principle of part performance is not applicable in case of unregistered gift deed. Now coming to the plea of adverse possession that pleaded by the plaintiff appellant, this court finds that PW1 deposed in his evidence that defendant number 1, after execution of unregistered gift deed, delivered possession of entire suit land as mentioned in Schedule A of the plaint, and at the time of delivery of possession, defendant number 1 asked him to use and occupy 1 katha of Schedule B of plaint and occupy the remaining portion as permissive possessor. PW1 further deposed that plaintiff, accepting the gift from the defendant number 1, entered into the possession of 1 katha of land as mentioned in Schedule B of the plaint, along with remaining land, Schedule A land, on 5/10/1990, and constructed his residential house within a month with kacha structure. PW1 further deposed that in October 1990, he requested the defendant number 1 to execute a registered sale deed in respect of 1 katha of land, upon which the defendant number 1 refused to do so, whereas he has been occupying the Schedule B land for his residential purposes, openly, uninterruptedly denying right, title, and interest of its true owner more than the statutory period of 12 years. Hence, from the evidence of PW1 as well as from the contention of the pleadings on record, this court finds that plaintiff appellant claimed that right, title, and interest of defendant number 1 over the suit land stands extinguished since he has been in possession over the suit property from the year 1990. Now some law points are discussed, Lordship, and after that, it is the finding of the court that paragraph 56, page 147.
Earlier, this matter was heard.
Lordship, in this matter, there is a condonation application. In that case, notice was issued, then private respondent appeared, Lordship. Thereafter, after 2 years, condonation was allowed. Then RSA was numbered. It was listed several times on to earlier occasion by the time they said, how many time they said?
Last occasion, for the
Last
time being,
occasion.
it was.
Time was taken, Lordship.
Because prayer was made for passing it over for the time being.
We
That
prayed
way I had some
over, then
difficulty. That is why.
Due to some difficulty,
It was heard by some other court, no?
yeah, heard by, yes, Lordship. It was earlier heard by some other court,
There were markings on the judgment, that's why I'm asking.
Lordship.
There are markings on the judgment, I think. on-
Justice Borua heard.
Borua,
Uh,
heard.
Subsequent
Borua.
question of law, it was heard, I think.
Yes.
Mm.
Thereafter, it listed 3-4 times, maybe, Lordship. On last occasion, we prayed for passing over the matter for the time being. Then due to some difficulty, it was possible.
147, page 147.
Yes, Lordship. Page 147, paragraph 56.
Mm.
In the light of all the aforesaid discussions, this court finds that plaintiff appellant failed to prove his plea of adverse possession over the suit land, and further the unregistered gift deed does not confer any right, title, interest to the plaintiff. On contrary, the defendant number 1 respondent proved his right, title, interest over the suit land described in Schedule A of plaint on the strength of registered sale deed. This finding is perverse, Lordship. It is the, in counterclaim, defendant number 2 is the plaintiff for that counterclaim, Lordship. That is his suit, Lordship. For that, he has to prove his right, title on the basis of Exhibit A, which is a certified copy. And Lordship, the First Appellate Court discussing about the case of the plaintiff, Lordship, decided the right, title, interest of defendant number 2. As such, it is seen that learned trial court rightly dismissed the suit of the plaintiff appellant, and learned court further rightly and lawfully decreed the counterclaim of respondent declaring his right, title, interest over the suit land along with other consequential reliefs. Hence, the findings of learned court below not deserve any interference from this First Appellate Court, and consequently, the judgment and decree passed by the learned trial court is upheld. So this is the finding by the learned First Appellate Court, Lordship. And in the memo of appeal, we have taken some ground that as the certified copy was adduced, original was not submitted by the counterclaimant in his suit, Lordship. His right, title cannot be declared, Lordship.
Okay.
And moreover, Lordship, counterclaim is barred by limitation, and Lordship, already we have since October 1990, we are possessing the suit land. It is admitted by all the parties, Lordship. So there is no proof is also required to prove that fact that we are in possession of that plot of land. Defendant number 1 is also admitting, defendant number 2 is also admitting, but both the courts held that, Lordship, as we admitted the execution of the registered sale deed in favor of defendant number 2 by defendant number 1. No need to prove the exhibit A, Lordship. But from plaint, I will show your Lordship that there is a denial of that. We raised an objection that behind the back of the plaintiff, the registered deed was executed. Para 4, page 8, Lordship. That in the month of March 2003, the defendant number 1, due to his ulterior motive, without having any possession, right and authority in respect of 1 katha of land out of the total land measuring 1 bigha, 1 lesser land of plain schedule A, behind the back of the plaintiff executed a registered sale deed in respect of entire land of the schedule A of the plaint in favor of the defendant number 2 by registered sale deed number so and so. So both the courts are perverse in holding that, Lordship. The plaintiff already admitted about the registered sale deed. And in this case, what happened, Lordship, in the meantime, decree was executed. I was already out of possession. Already, Lordship, after outcome of this regular second appeal, section 144 benefit I can take, restoration. So I am not praying any stay order in this case at this moment.
Already executed.
Yes, Lordship, already executed. And it is the admission hearing is in between court and the appellant, Lordship. There is nothing to argue by the respondent during the admission hearing, Lordship. Only in case I pray for stay, then your Lordship may hear the other side, Lordship.
Stay prayer has become redundant, my lord, because the execution was carried on. Decree was executed in the month of October 2023, and I am put in possession, I am enjoying the land. So, my lord, the stay petition has become infructuous.
She is not asking for stay.
There will be no injustice.
She is not asking for stay.
Stay petition may be disposed of because they.
No, Lordship may held that it's become infructuous. And I am not praying for stay, your Lordship. Ultimately, if I own these cases, then only I can file 144 petition for restoration of possession. And in items RSS 68, Lordship, I'm praying to admit the appeal on the substantial question of law, page 3, 1 and 3.
Page?
Page 3, 4.
3 and 4, your substantial questions of law.
1 and 3. And 5, Lordship, any other substantial question of law that may arise at the time of hearing. And in 69, Lordship, that is against the dismissal of allowing of the counterclaim. Page 3 and 4, substantial question of law number 2 and 5, Lordship. And 6, any other substantial question of law. So my humble submission before your Lordship to admit this appeals, Lordship, and call for the trial court records, Lordship. Even Lordship, admitting of this appeal, there will be no irreparable loss and injury.
I know,
They are
I
enjoying,
understand.
Lordship.
That's why I am not very hesitant, but I'll just hear them what they have to say.
Lordship, I'm deeply upset.
You want to say something on the admission of appeal?
Yes, my lord. Though at the time of admission, I may not be allowed to submit, but even then, my lord, my humble submission before lordship, that the general rule is that the High Court may not be pleased to admit a second appeal when both the courts below came to concurrent finding is there, my lord. Unless it is not an absolute law, no doubt, but unless and until perversity is shown that the judgment suffers from perversity and there is wrong, erroneous application of law. In this case, there is no such perversity that has been imputed by the learned friend for the appellant. My humble submission before lordship that it is when the law says that an unregistered gift deed does not confer any right It is an admitted fact that the plaintiff entered into possession of the suit land.
Just a moment, you see, I understand unregistered gift deed. She has a point that this your counterclaim is barred by limitation. You have to say something on that.
Regarding counterclaim, my lord, I am governed by Article 65 of the Limitation Act. So, because I am claiming possession on the strength of title. So, it is not barred by limitation. Within 12 years, I have come. My counterclaim was filed within 12 years because my claim for recovery of possession on eviction of the party on the basis of title. So I'm governed by Article 65 of the Limitation Act, and I am very much within time, my lord. There is no question of limitation.
And then she's saying that she's claiming right title on adverse possession. You have anything to say? on
Adverse
this?
possession.
Yeah.
No, my lord, permissive possession is not adverse. It is an admitted fact that we have also admitted that he entered into possession of the suit land on the strength of an unregistered sale deed, gift deed.
suit was
Let
allowed.
us decide the suit.
Lordship, to decide the suit, it will take long time because Lordship, some of the respondents died. They have not filed a substitution petition till date as per office note dated 17/12/2023. Lordship, if pleases, then some have not refused. There are so many respondents, Lordship, near about 40.
Some expired, Lordship, and
40.
some refused to accept the notice, Lordship.
So when somebody has refused, then it is
That,
to be served.
that is deemed to be served. But Lordship, there are respond number 7, 8, 10, 12, 23, 28, 29, 31, 35. They have died.
That machine is not functional. What is
No, machine is functioning, Lordship. And I only want to repair only the bamboo fencing. It is my only source of earning, Lordship. My livelihood. And Lordship, the suit was decreed against that they have preferred an appeal. The appeal got dismissed. Again, the dismissal, they have preferred its second appeal. And the order from this honorable only to maintain status quo. And we are ready to maintain the status quo. Only the thing, Lordship, the repairing the bamboo fencing. Otherwise, Lordship, my livelihood is hampered. My limited prayer to
Instruction, Lordship, regarding whether this machine is in function or not, Lordship. If it is in function, Lordship.
Why? This is not your machine. This is his machine.
Yes,
He
Lordship.
set instructions. He is the better person to say it.
And
Let them take
for
instruction,
no, I have
He
taken.
is saying it's functional and his livelihood depends on the machine.
Lordship, for a moment, I have preferred this IA in the month of August 2023, and they have not filed their objection for last 2 years. They have only filed their objection on 14th of August 2025 after 2 years. If they have serious objection, they could have filed it earlier, and that is to when the case is listed before a honorable court. On Lordship, if Lordship is to look at order
You are the
331.
appellant.
Yes.
Concurrent judgments.
Yes, Lordship.
2 concurrent judgments.
Yes, 2 concurrent judgments.
They are in possession of the suit land.
Yes, Lordship.
So, okay,
so far as
it's okay.
rice mill is concerned.
Huh?
So far as
Okay,
rice mill.
only the rice mill. They are in possession of the rice mill area. So let them repair the rice mill area. They will not build any house.
Lordship,
Yes.
they have not
We'll
specified
repair
what kind of repair.
temporary
Lordship,
only.
It is extend to the up to the fencing, bamboo fencing.
Yes.
I have no objection, Lordship.
On-
Only
on-
bamboo fencing. no
Only
permanent structure,
bamboo fencing, Lordship.
no wall structure, no RCC structure.
Yes, yes.
That may be
No
reflected in the
wall,
order.
No one, Lordship. Only bamboo fencing and temporary. It is written in my petition itself, Lordship.
Where, which paragraph?
Lordship will find paragraph 4.
All right, only up to that extent.
Yes, Lordship.
You interfere if I go beyond that extent, you interfere and you
Yes.
place your submission.
Yes,
Lordship. My
I'll
objection
just
may be
get the
recorded.
order in your presence. Learned Counsel, Mr. K. Atria, no?
SN Krishnatria.
SM Krishnatria.
SN.
SM Krishnatria is present for the applicant. It was IA number 2739. Applicant, comma, respondent. You are the respondent, no? You are the respondents?
Yes.
Who have filed this application with prayer. Your prayer to repair a rice mill.
Yes, only the campus of the rice mill, where the rice mill is situated, only the bamboo fencing, Lordship. Paragraph 4, Lordship will find. Page 8.
To prepare to repair the rice mill, because here is written only rice mill.
Yes.
So I write rice.
Yes,
mill.
only rice
Then
mill.
my order will be something else.
Yes.
To repair the rice mill. Heard Learned Counsel, Mr.
TH Chaudhary.
TH Chaudhary appearing for the appellants, stroke opposite parties. who has raised objection stating that the suit premises may be encroached, according to you.
No, this rightly within
It's
the
already,
setback.
has raised objection against this petition, full stop. Yeah, I have considered the submissions at the bar. It is submitted that the applicant's livelihood depends on the rice mill, full stop. The rice mill is getting damaged. It is submitted that the rice mill is getting damaged as the rice mill, as the walls and fencing,
Bamboo fencing was it,
as the bamboo fencing is it has been,
and the shades.
as the bamboo fencing and the shade has been destroyed. Full stop. Annexure A are the photographs of the rice mill. Full stop. Considering all aspects, a direction is given only to repair the shade consisting of the rice mill and the bamboo fencing surrounding the rice mills. In terms of the above observation, this application stands disposed of.
Deeply
RSA
obliged.
to list after puja vacation. RSA to list
Okay.
after puja vacation.
Deeply obliged, Lord.
আৰু এটা লগত আহি যাব নিজে আহি যাব অটোমেটিক্যালি
Item 23.
May I please, Lordship, my lord, in this petition, my lord, they have appeared, my lord, service has been completed, be listed for admission, my lord.
Okay. Both the parties are present. Please this matter for admission. After puja vacation,
No, my lord, some urgency is there, my lord, on 19th of September, my lord.
it will be the third week or the fourth week.
It will be third week, Lord.
Okay.
19th of September.
There is no urgency because they are challenging the judgment decree by way of this title suit with which under challenge. The maintainability of the suit was dismissed on the ground of maintainability. In fact, this revision
You
also.
get chance in your admission stage.
On 19th.
On 19th. Obliged.
Item 24.
In this case, service of report in respect of respondent number 4, all are APR, my lordship. All the respondents are APR except respondent number 4. He is already, as far as it's not dated, she is already expired, my lordship. There is a report in the office note, my lord.
Passed away.
Yeah, respondent number 4.
Okay. Latest office note.
Yes.
Then you will file you give the if they are related to you.
There is other.
You give the sorry.
Other respondent. There are
Other respondents also.
There are 8 respondents. Only 4 is expired.
Learned Council Miss Arbigam, no?
Arbigam
is present for the applicants. Learned Council Miss S.G. Burua is present for.
Respondent number 2 and 3, my lordship.
Respondent number 2 and 3 and Learned Council Mr.
A Burwa for respondent number 1.
A. Burwa is present for respondent number 1. Office note dated 3/9/2025 reflects that respondent number 4 has passed away.
24.
Oh.
No, no, I am appearing in the case of respondent number 8.
Learned Council
And
Mr.
B. Sarma. Lordship.
B. Sharma.
Yes.
Is present for respondent number 8.
8, Lordship. But the thing is, in the document which they have found, wherein from 20, after 28, the annexure 3, 4, 5 are missing. Rightly, 74 it starts. After 28.
She will furnish it.
Here in the same also.
She will furnish it. So all the respondents are here except respondent number 4.
Yes.
Are you related? All the respondents?
No.
Then you obtain the details and submit to respondent number 4.
5, 6, 7 are, my lordship, I guess no sons.
The notice has been served.
5, 6, 7, my
Yes,
lordship.
yes.
They are sons of 4. Sons of respondent number 4.
Okay, then you don't have to, I don't know, there'll be other siblings
Maybe,
also.
my guess.
Maybe.
You obtain details.
My lordship, matter may be fixed for admission.
How the documents? The
Yes,
documents,
sir.
how without serving the document, how the whether the mentally
No,
come up like.
Extra
Substitute first the legal heirs of respondent number 4.
Legal heirs are appeared. Respond number 5, 6, 7 are the legal heirs of.
They do not have other children. He doesn't have other children. 5, 6, 2, 3 children. Respondent number 4 survived by only 3 legal heirs.
Don't, that is.
Lordship, the Kalatnama is filed with regard to respondent number 5,
5,
6,
6,
7.
7,
But
yes.
today the council has not, therefore, my lordship, I pray that matter may come up
Yeah,
because
yes.
in that case, clarity will be.
Yeah, we will, she's right. Petitioner also to furnish copies of relevant documents to the respondents.
Annexure 3, 4, 5. That is
Relevant documents.
missing.
For annexure 3, 4 and 5. To the respondent. List in the orders column after puja vacation. After puja vacation.
My lordship, interim order may continue.
You have an interim order, no?
Yes.
Interim order shall remain in force till the next date of listing.
Item 25.
Obliged.
Maybe the lordship. I am appearing for the respondent.
Petition is not represented today. Learned counsel, Mr.
BW.
PW is present for the respondent. One respondent.
Solus.
List the matter after puja vacation.
Item
26.
Wait to the lordship. Lordship, I have prayed for by order, that's why it has come, lordship. Lordship, may kindly produce the office note dated 19/6/2025. In my view, the services are complete, my lord, and the respondent has not appeared. 19/6/2025, the office note.
One respondent.
One. Your lordship, actually, my urgency was there. If lordship could spare just 5 minutes, it will be.
No. We'll have to hear both the sides.
Lordship.
We'll have to hear both the
But
sides.
they have not appeared, that's why, lordship. The services are complete.
We'll place it for admission.
Then lordship, on Monday, lordship, because why lordship, I'm saying, because this is a covered case. Already, this honorable court has passed similar placed petitioners are already given the relief. I have approached in a later stage because my land was taken in the later stage. If I may just, it's 5 minutes, if lordship, well, I will not force. But
No, you see, there's a 1, 2, 3, 4 page order.
No, that is
After
there.
hearing you and giving a detailed
Yes, lordship.
reasonings
Yes.
in detail,
No,
your
lordship,
prayer was not considered.
No, lordship, my prayer was not considered with regard to the interim stay. But lordship can dispose it off if your lordship can just, it is not that big.
No. Let us take one more date. Then if they don't turn up, then I'll dispose it.
Then if possible on Monday, because what is happening,
Monday পাই নেকি চাচোন? Hearing অলপ time লাগিব.
lordship, this
পাৰি ন? On Monday, okay.
lordship,
Learned counsel, Mr.
P. Deca, lord.
P. Deca is present for the petitioners. The respondents are not represented today. List this matter on Monday.
Highly obliged.
So for the office note dated 3/9/2025, it is indicated the notice taken upon the respondent number 1 and 2 has not been served, isn't it? And I want to take the fresh
Yes, learned counsel, Mr.
P. Thakuria.
P. Thakuria is present for the petitioners. Full stop, petitioner may take fresh steps to issue notice to respondent number
1 and 2.
1 and 2.
What's it?
Item number 30.
Oh, returnable within 4 weeks.
Lordship,
Hmm.
in this, sir, actually, why this came for others, we are a bit confused actually, because today was the, should have been a date for the hearing on the bail. So we are also a bit confused why it has came to the orders, because we are new, that's why it has came for orders, or we have filed one IA, that's why it has came for orders.
Because we have filed one IA.
IA, okay, that's right. So we had filed this IA actually. I remember, okay.
46.
When we had filed the IA actually, basically we wanted to bring to the court three things actually. One is that your honor, the arrest memo, actually the arrest memo under section 50 was there itself. But here the 47 was
You
not.
are convicted already.
No, I don't think so, they're convicted.
Lordship, trial is going on.
Trial is going on, trial is going on. There were totally
It
6.
should have come for bail hearing, no?
Bail hearing, yeah, it should have come for bail hearing.
So
but
we'll fix it for bail hearing then.
Yeah, that's right. That's right.
List this-
Lordship, may I pray a short date? My friend has
Yes,
came
yes.
from Agartala, Tripura. So.
List this matter for no আগরতলা বা একই এই দুদিনের ভিতৰত কৰি দিয়া
11 September will do.
List this matter for hearing on 11 September for bail hearing on 11 September. We have everything, no?
Lordship,
LCR and everything.
LCR is there.
Okay.
Next.
Item 31.
May it please the Lord.
Hmm.
My Lord, and small error, my Lord, in our petition, my Lord. The cost title, my Lord, before the name of his father, my Lord, petitioner's father, my Lord, inadvertently late was, my Lord, inserted. And consequentially, my Lord, in the order passed by my Lordship, my Lord, that late has been, my Lord, put, my Lord. That is why, my Lord, this IA has been filed. The father is alive, my Lord.
Okay. Heard learned counsel Mr. D. Das.
MK Das. MK Das.
Learned counsel Mr. MK Das for the applicant. Mohibul Haq, alias Mohibul Haq, alias Moni,
My Lordship.
and learned additional PP, and the like full stop. Heard learned additional PP Miss S.S. Bora. It is submitted by the learned counsel for the applicant that inadvertently in the cost title of bail application number 2534/2025. The name of the applicant's father was referred to as late. What? Late what?
Late, my Lord. Late, Abdus Samad Ahmed.
As late Abdul Samad Ahmed. It is submitted that the applicant's father it is submitted that there was a typographical error in inserting late as the applicant's father is alive. So the error in the cost title.
Cost title.
Cost
lord,
title.
cost title,
Rectify the error in the cost title or
As
in
well as
the.
the- as
cost
well as
title,
order.
consequential order, my lord.
The error in the cost title of BA number 2534 of 2025, as well as the order of this code dated
29/2025.
2025 in BA number, in the same BA number 2534 stroke 2025 may be corrected, and the late may be deleted. Late and the word late may be deleted from the name which has been typed while referring to the applicant's father's name.
My lordship, rectified cost title will place before the registry. Deeply obliged.
Amended cost title may be submitted by the applicant.
Deeply obliged.
In terms of the above observation, I stand disposed of.
Item 32.
May I please? As per office note, your lordship, that respondent number 3 has not been found there. Your lordship, go through the office note in connection with this IA application. 59, your lordship.
Address is not found, no?
No, your
Found in the
lordship.
address.
Yeah, yes, yes, sir.
So what you propose to do now?
Your lordship, may I submit it?
Yes.
As per, if your lordship, my, in the said IA application, your lordship, I have annexed one lead petition order where the respondent, here the respondent has appeared and her address was the same. Your lordship, go through the page number 11, your lordship. Just 1 second here.
Where?
In IA application, your lordship.
Which page?
In page number 11, annexer 1. Srimati Susitra Kumari, daughter of Vishwanath Mahato, resident of village Solagaon, Bokazan district. Here in the said brief petitions, she has appeared after sending notice in the said address. Right now, the said respondent is not found there. So that is the thing, your lordship. They are delaying the process by way of these tactics, your lordship. And most important thing is that if I have prayed to stay the pensionary benefit of my deceased husband, which is supposed to be released in the name of this this respondent, your lordship. At least right now, I pray before the honorable court to stay the, they say to direction may be given to the respondent number 1 and 2, not to release the pensionary benefit.
Why?
Because, my lord, the facts of this case is that, may I submit, your lordship? The petitioner in connection with this case, in the year 2002, she got married with her husband, namely Probin Bhuya, who was earlier as a grade 4 employee of MES Military Engineering Service, your lordship, which Kechpur, your lordship. Thereafter, due to some marital discord, they have separated. However, there was no any formal decree of divorce. So, my lord, in the year from the year 2012, she along with her daughter live with her parental house. Thereafter, in the year 2014, when when her husband did not pay any maintenance, she filed one maintenance petition before the Judicial Magistrate First Class Romia, where her parental house, your lordship. Then the said her husband, Probin Bhuya, appeared there. He stated that yes, she is the legally married wife, and one child was born out of their wedlock. Thereafter, the said JMFC ordered judgment and directed the her deceased husband to pay a monthly maintenance. So, my lord, accordingly, her husband paid her the maintenance amount. In the year when the COVID-19 was erupted, then her husband refused to pay the said monthly maintenance.
So she went to her deceased husband's house, office address at MES Saloni Valley. Thereafter, she got the information that her husband again he has a second wife without having a decree of divorce. But when she asked them to provide the same information through documents, they asked her to file one RTI application. Accordingly, she filed the RTI application. After that, she got the information that her husband got an ex parte decree of divorce without informing her. However, Your Lordship, at the time of the retained statement of the said maintenance case, he never stated all these things. Accordingly, she filed one petition before that the said ex parte decree of divorce was passed by additional district and session judge stage 4, Your Lordship. So she went there, take out the certified copy. Then she filed ex parte decree of vacating the said ex parte decree of divorce, Your Lordship. During the said process, her husband appeared there, filed his written objection. But the thing is that, Your Lordship, in the year 2022, 9/11/2022, he died due to he was a dreaded alcoholic. So due to kidney failure or something like that, he died. Thereafter, this petitioner again filed one substitution petition because, Your Lordship, the respondent authority, the MES as well as the Union of India, wants to release the said pensionary benefit as this respondents this respondent and's name was substituted as the wife of the said the petitioner's husband, Your Lordship. So she filed one substitution petition where she appeared there by way of this address, Your Lordship. She put her address. It is whatever we have mentioned in our.
So now she's getting the benefits.
Yes, right now the respondent authority wants to release the pensionary benefit. Already the respondent number 1 and 2 and 1 and has processing in the said pensionary benefit, Your Lordship. So my respectful submission before this honorable court that they have this lady has falsely stated that she was not there, and by way of some illegal or illegal tactics, she refused to receive this petition, Your Lordship. So my respectful submission is that at least right now direction may be given to the respondent authority 1 and 2 not to release the pensionary benefit. Otherwise, my civil revision petition will be infructuous, Your Lordship.
You must go before a division bench.
Yes.
This has been passed by a single bench.
No, Your Lordship, one more thing.
To release the pensionary benefits.
Yes, Lordship.
This has been passed by a single bench. You will have to go before a division.
No, Your Lordship, I am the petitioner in that petition. I am the petitioner in the said petition.
So you will have to file before the division bench. You ponder over it.
Yes, Lordship.
I won't be able to stay the release of funds. I can only issue notice.
Yes, Lordship, already need to issue a
This
notice.
order has been passed by a single bench. How can I stay the order of a single bench?
No, Your Lordship, that order was not passed by a single bench.
No. To release the benefits in her favor, it has been passed by the single bench.
Yes, Lordship.
How can I stay? You must approach the division bench.
Lordship.
Otherwise, this I can decide, I can fix an early date and decide.
Yes. Yes, Lordship.
But initially you have to serve the notice through any means. You'll have to
Justice
serve the
service,
notice.
I'm serving it.
Justice
through-
service,
yes.
yes. Learned counsel, Mr.
SD Roy, Your Lordship.
SD Roy is present for the petitioner. Who serve the petitioner may take steps to serve notice upon the Respondent number
Respondent number 3, yes.
3, through Dusty Service. List short date?
Yes, Lord.
Short date এটা দিও।
পূজার আগতে দিবেন।
পূজা আগতে,
Before Puja.
before পূজা। On 18 September.
March on.
Item 33.
My pleasure, Lord. But sir, present IST for condonation of delay, Lord. There is a 44 days delay in the preparing the appeal, Lord. So at least this is a notice may be issued, Lordship, with the respondent.
Issue notice to respondents returnable within 4 weeks, list accordingly.
Obliged, Lord.
Item 34.
Make please be Lord. For those delay petition, Lordship, first time Lordship, notice by kindly.
Issue notice to respondents returnable within 4 weeks, list accordingly.
Item 35.
We treat your lordship. Your lordship, this matter has come up for the first time. Delay of 76 days, your lordship.
Okay, issue notice.
Yes, your lordship.
Issue notice to respondents returnable within 4 weeks. List accordingly.
Item 36.
Lordship, we have filed an application order and rule 9 for releasing some documents which has been exhibited by myself in a suit that is in the original case record. So I want to take back the document by giving a photocopy in the record. That should be done in the trial court itself. That is not done. They have also no objection to that effect for releasing the document. We'll give a photocopy to the registry and take back the document. My document.
Why it was not done in the trial court?
It was not filed by the advocate concerned before the trial court. That is why also we have to file here. Two exhibitors.
From this LCR?
Yes, Lord.
LCR.
On the title suit.
Exhibit 1, 2 and 3. Original of exhibit 2 and 3. We'll give a photocopy to the registry and take back the original by making proof in original.
You'll have to, I think certified copy you'll have to give, not
No,
photocopy.
not certified copy. Proof in original. I have to make the registry.
Okay. All right, Jay.
Lordship.
Order 13, rule 9.
Lordship.
CPC contestant, sir.
Return of admitted documents.
I'll see. No, CPC. Logos ले यहाँ पर.
एक और लोग नहीं कर देखो. These are my documents and I have exhibited.
In case of a party to the suit, a certified copy. You are party to the suit now.
I have my suit. My suit was dismissed,
Then-
appellate court allowed.
So a certified copy is required. In case of any person, an ordinary copy. You are not any person, you are party to the suit.
Lordship.
One certified copy, anybody will certify your copy.
No, this is my document, give deed.
See, you see,
I-
can be returned on before the appeal has been disposed of, provided in case of party to the suit, a certified copy of the original document.
Lordship,
But you will have to obtain a certified copy and give it. Where is the problem? You take the document.
I can take the document from the High Court also by giving a certified copy. But
Yeah,
proving
now you
original-
cannot give a certified copy. You take the document, get it compared, and then you furnish the certified copy later on. According to the provisions, I will mention only according to the
Lordship can
provisions.
record that I will produce a certificate copy of the document before the registry. After taking back the document.
Yes,
After taking back the document, I will give a certificate.
yes. Because the document is here, how will you obtain a certified copy?
Lordship,
You won't be able to obtain the certified copy.
I will take back the document giving
No,
photostat copy.
that registry will certify the document. Registry
Then
itself,
Lordship may record, registry will give a certificate copy.
no, that,
Because-
any other registrar, not the same registry. Because you'll be taking from one registry, that same registry won't certify the document. Any other registry will certify. As per the provisions of this order 13 rule 3,
Nine.
rule 9.
But it was not impounded. In case of impound of documents.
No,
then-
no, not impounded. Not impounded. It is mentioned like that. So as per the provisions. I'll just mention registry to give the copy of the document.
Generally, we make the Shirosar
The lower court, the
Shirosar certified it to be
certified
original.
copy gives
Then
it to you and you can take it back in lower court. That is what we used to do in lower court.
here also the registry conduct.
Yes.
Registry conduct.
Here I
Always-
haven't seen such orders. This is the first time I have come across such order.
Lordship, because it was not taken back in the trial court. That is why.
That is why. Maybe I
Then-
have seen one such order in the Fairness Tribunal once and here today. Earlier I haven't seen such orders.
Lordship, in the Guwahati High Court registry also, there are some registrar. They can, the authority to
They
certify.
are all gazetted officers. They
Gazetted
can certify.
They can certify.
Learned Counsel Mr. S.K. Gusami is present for the applicant and Learned Counsel Mr.
W Hawk.
Huh?
W Hawk on behalf of Mr. A. Sattar.
W. Hawk is present on behalf of
Mr.
Mr. A. Sattar representing the respondents.
Appellant.
Okay,
Appellant
representing the
in the
appellants. Opposite parties, representing the opposite parties. The learned counsel for the applicant has submitted that the
Original gift deed number para 5, Lordship, which has been marked as
has
exhibit.
prayed for Likita, has prayed to take back the original gift deed number 122/1996. Okay?
Yes, Lordship. And gift deed
Dated
number.
10/1/1996, as well as the gift deed number 4523/1999, dated 12/11/1999. To stop. It
Which
is
is-
further submitted that the petitioner will return the original copy of the gift deed, original gift deed, original copy of the gift deed, aforementioned gift deeds as any point of time, at any point of time. It is further submitted that the petitioner pledges, PLEDGES, pledges to return the original aforementioned gift deeds at any point of time as directed by this court as and when necessary. The learned counsel for the opposite party has raised no objection. The petitioner may take back the gift deeds from the registry of this court after submitting copies of the gift deeds which may be compared in original, and also the petitioner is to submit the certified copies of the aforementioned gift deeds after obtaining the originals of the aforementioned gift deeds. নাম কিটা লিখি দিবা aforementioned য'ত আছে নাম্বাৰ কিটা লিখি দিবা ডেটটো লিখি দিবা দুটা আছে মাত্ৰ
Lordship may also record that superintendent may certify, superintendent of the registry, because he is authorized.
He'll certify. They'll certify. Anybody will certify. Certified copy you can.
So otherwise, Lordship, they will say that we have to go again to the lower court and take a copy.
They have everybody here. Old commissioner also can certify. Anybody can certify.
No, otherwise they will confuse us.
No, they won't.
Lordship clarify.
That's a speaking order.
Lordship will clarify. Lordship little better. Lordship.
What?
Lordship,
What should I mention?
Lordship can record. Let's original. Make a photoset copy of the original, and that will be certificate with the registry.
Mentioned already.
That will be certificate with the registry. By the affidavit commissioner.
I have already mentioned compared in original. I have already mentioned, and then you will certify furnish a certified copy of the gift deed. I've already mentioned. Any problem you come to me, I will again clarify. I'll pass a speaking order then. Don't worry, it's a gift deed.
Lordship, record that original will be returned to us.
Yes, I have already.
Obliged.
Right. Oh. Disposable.
Item 37.
Lordship, this is a matrimonial appeal with a prayer of a condemnation of delay of 158 days.
We'll issue
So
notice.
at this stage, I pay
Yes.
for this notice to be issued.
Yes. Petitioner to take steps to issue notice to the applicant to take steps to issue notice to the opposite parties, returnable within 4 weeks, list accordingly.
Item 38.
Lordship, the matter has come up for the first time. Delay of 76 days, Your Lordship, in filing the
Okay, same order.
obligation.
Item 39.
May it pleases your lordship. Your lordship, this IA is for condonation of delay of just 7 days in filing the connected revision petition. My prayer is that.
Can be condoned, but you will have
Can
to
be
issue
condoned.
notice.
Lordship,
You will have to issue notice. Can be condoned.
it can be condoned, lordship, this is only 7 days. I have shown the sufficient reason at page number 6, para 7.
See, it is not a MAT appeal. You
No,
take
it's not.
steps, issue notice, same order. If MAT appeal, then I could have condoned the delay, not MAT appeal, MAC appeal.
MAC.
Ah.
Within steps to be taken within
Yes,
3 weeks.
yes. 4 weeks, yes.
Deeply obliged.
Item 40.
May I please, your lordship? Your lordship, this is an interlocutory application for condonation of delay of 27 days, your lordship, preferring to.
Hearing.
Much obliged, your lordship.
Item 41 for hearing.
Lordship, I think I'll wait for a day, Lordship. Because at this time, I couldn't fully go through the case was earlier dealt by, when appeal was filed by Dilip Majumdar Da. So later on it came to me. I went through some of the records. I could not, just to help Lordship in the page numbers I have to show in the LCR. So Lordship, maybe short date.
Because I have the third party here in my lord.
We'll fix it after puja vacation.
As your lordship.
Yes. List this matter after puja vacation.
Date may be given. So old
Hearing,
case.
list this matter for hearing positively on
I'm third party.
30
Yeah,
October.
The insurance.
30 October.
30th October.
30th.
Then given for the policy to.
Policy to nine.
Item 42.
Hello, bless.
Meet the lordship. Lordship, this matter was listed on my mention, lordship, but while listing a matter, lordship, inadvertently the name of the respondent was not shown. Their names were reflected in order dated 30/10/2023, lordship. The matter is already been talk of compromise is going on between the parties, but if the matter is referred to mediation, then it will be convenient for both the parties to come for an amicable settlement, lordship. But in their absence, the matter may not be
Referred
sent
for
for
mediation.
mediation. That may not be. Also, a direction will given to list the matter
To
by
reflect
showing
their
the
names,
name.
yeah.
So that their names are reflected in order at 3010. Because without their absence, if the matter is sent for mediation,
Yes, yes.
they might have some grievance.
Learned Counsel, Mr. S. N. Krishna Thaya is present for the appellants. List this matter for hearing on.
Lordship, not for hearing, for orders, because the
Okay. List this matter for hearing, list this matter on
next
application episode.
Lordship, it will send for mediation only.
Okay,
Lordship.
okay.
For mediation.
What did they put application ago did on 17 September by reflecting the names of the learned counsel for the respondents.
Mr. T.K. Das and B. Kuwar.
They will get yes. Are also negi?